What's up, everybody? Welcome back. The defense has rested, the evidence is over, and potentially the worst day of the entire trial for the Commonwealth. We'll talk about if it's enough. As we always do at the end of the evidence, we're going to vote on where you guys stand on the charges so far. We're going to break down the last three defense witnesses. We'll talk about closing arguments. We'll talk about what Lally did right and did wrong on cross-examination of these witnesses and where we think this trial is headed if we have the idea yet. So make sure you guys hit that like button and subscribe to our page if you haven't already. Let's get into it. So the defense finished their case in chief today with the last three witnesses. We knew what to expect based on the interview last week with the defense attorney saying the pathologist and the two accident reconstructionists were coming. We knew the accident reconstructionists were going to be good based on their education and experience, but it was interesting because we heard Dr. Russell's actual opinions in the voir dire, and Lally got a free bite at the apple, basically getting to cross-examine her. But what he didn't get, and what the defense pushed back on very hard, was that Lally should not get to depose basically these two witnesses for what their testimony was going to be and what their opinion was going to be. After we get through these three witnesses, maybe during the last witness, we'll throw up a poll on where you guys are on second-degree murder and manslaughter. Those I think will be the two that we'll focus on, guilty or not guilty. So there'll be two different polls later on that we are going to post. I want to go through most of the evidence first. And then, as always, we'll see if closing argument changes anybody's mind. Because closing arguments, the research shows, usually doesn't change someone's mind. Instead, they reinforce what jurors already believe. They give jurors what they need, the strongest arguments for their side to go back and argue on behalf of the side that they believe in. And I think a lot of you can relate to that. As we've gone through this trial, you probably believe in one side or the other, and you've fought hard and argued for the evidence for that side. And many times back in jury deliberations, that's exactly what's going on. So we start out with Dr. Sheridan, who's been a pathologist for 100 years, forensic pathologist, and he's only done 13,000 autopsies, so we're not sure about his experience. That's a joke, obviously, and being sarcastic. I almost posted on Twitter. I literally had the tweet ready, and I said, can we really believe anything this guy says? He's only done 13,000 autopsies. And then I knew that it would be utter chaos and people would not understand the sarcasm. So, and if you have to tell people you're being sarcastic in a tweet, then does the tweet really work? My answer is probably no. So anyways, obviously, older gentleman, been doing this for a long time, and he explains what the injuries are. He explains how the, arm injuries, scratches, bites, whatever they are, scrapes from a tail light, happened before death. She wants, Miss Little is the one that did the direct. She wants him to say they're inconsistent with a car accident, and the Commonwealth fights hard against that. But eventually we get to the bulk of his opinion here that we're going to listen to together. And the judge, again, I think she should have let Dr. Russell testify to it, but it wasn't a big deal because she let this doctor testify to it. And he testifies to his vast, vast experience, thousands of car accidents, hundreds of dog bite or animal injury cases that he has specifically worked on. He knows what they look like. He knows what they look like. So if this guy's not going to be able to testify to the consistency or inconsistency of these kinds of injuries, who can? So anyways, he was allowed to, and let's take a listen to it.
Dr. Sheridan, how many autopsies have you conducted on individuals who were involved in pedestrian vehicle motor collisions?
Involved in what pedestrian vehicle?
Yeah.
Well over 100.
What other experience do you have in terms of conducting autopsies with individuals who have been involved in motor vehicle collisions?
Well, I mean, if you take motor vehicle accidents in general, they'd be probably nearly a quarter of my total number of autopsies. So in other words, that'd be close to 3,000. Yeah, that's about right.
Based on your professional experience, what is your opinion regarding whether those injuries are consistent with a pedestrian being struck by a motor vehicle?
Objection.
I'm going to allow it.
You can answer that, Doctor.
Hmm?
Can you answer that?
I can answer it, yes.
So go right ahead.
Okay. Okay. But the question was, to be precise, can you just rephrase it? I mean, I said yes, I can answer it, but I can't remember exactly how you phrased it.
Yes, based on your extensive training experience, what is your opinion regarding whether those injuries are consistent with being struck, with an individual being struck by a vehicle?
If you mean struck in that part of the body, on the arm, like
Yes.
directly, I would say no, it doesn't look like that at all. Mhm.
And can you explain that?
No, it doesn't look like that at all. Okay. And this is one of the differences between the state's witnesses and the defense's witnesses is there's no pussyfooting around what they think they saw here, what they think they found here. None of that. They are purely just telling us this doesn't make any sense what the Commonwealth is arguing. And that's going to be a common theme throughout all three of these witnesses today.
Well, if you're hit by a vehicle, or whichever part of your body is hit, if it's a significant impact at all, you're going to get bruising, and we don't have any bruising here. We just have what I would call linear abrasions without any bruising. So that does not look to me at all remotely like an impact from a motor vehicle.
What would you expect to see if an individual's arm were struck by the rear of a motor vehicle?
Well, as I just said a second ago, primarily a lot of bruising, and that's what we don't see here. You might see, well, depending on the circumstances, you might see other things like a fracture or fractures, but you would at least expect bruising.
No, I just don't see that this could have been done in a motor vehicle accident. And I think that if it was in a motor vehicle accident, it would have shown bruising and potentially fractures. Now, here's why this is so important. And here's why this really seemed like it hit hard today with all three witnesses. Because all three witnesses to me felt like they confirmed one of the most important things that we cannot forget. And we as trial lawyers, we always think when we go into a case, it's very important that we don't forget what we tell the jury not to leave at the door. And in every trial, what do you hear lawyers tell juries not to leave at the door? Their common sense. And when you can present witnesses that provide scientific, medical, biomechanical backing to common sense, that is a recipe for success. And that's what I kept thinking about. I was like, yeah, obviously what this guy's saying, if you hit somebody at 25 miles an hour, there's going to be some bruising. There's going to be some fractures. And again, a lot of people were arguing, oh, you couldn't possibly cause death at 24 miles an hour. And I said, I've had cases, and it's funny. It's not funny. It's ironic or interesting that he said most of the ones that he looked at were children crashes. And that's most of my experience as well. Tragic cases. But if it's fast enough to end somebody's life, it's likely going to cause more than some scrapes on the arm. And that's common sense.
In your professional opinion, based on your many years of experience, have you conducted any autopsies involving individuals who were involved in any sort of animal attack?
Animal attacks in general, yes, quite a few actually. Well, when I say quite a few, it's not an enormously common event, but I've done probably at least a dozen or so involving deaths where an animal was involved one way or another.
Have you conducted any autopsies in which any individual was attacked by a dog?
Yes, I have a few.
Can you describe that for the jury?
Well, I'd have to just refresh my memory out of the blue here. But first of all, I had a number of cases, 3 or 4, I think, over the years involving children, was primarily children who were killed by feral dogs. And the dogs attacked the kid and killed them. So I had that a few times. But then I've also had cases where an animal or a dog particularly was involved, but wasn't the actual cause of death, so to speak, but they were involved in something that was happening and left some traces of their activity in the form of bite marks or scratch marks.
In your professional opinion, are those injuries consistent with an animal attack?
Are they consistent with what?
An animal attack.
I would say they are, yes. I'm not 100% sure about this, but my initial reaction when I saw this photograph was that it was probably an animal mark. And most likely, I would say a dog.
So some missed opportunities potentially for Lally where he just dropped the ball on some objections. He's objected to so many things, but this guy's like, yeah, not 100%. My first initial reaction was it probably was an animal, probably a dog or likely a dog. I'm not sure that rises to the standard to a reasonable degree of medical certainty that the judge has asked other witnesses, but Lally didn't object. And it's clear this guy thinks it's probably a dog. And guess what that's evidence of, and very important of? Reasonable doubt. The defense doesn't have to prove the case beyond a reasonable doubt. But if they can provide reasonable doubt which that's exactly what that statement is, I wonder what the judge would have done if Lally would have objected.
Scrape marks with the paws, and possibly also a bite mark from the teeth as well. Possibly. I'm not 100% sure. I didn't get a chance to analyze it right there on the spot, so to speak. But my basic impression is that these are consistent with marks caused by, say, a dog using his paws.
I think there would have been a pretty good argument that that didn't meet the standard, the expert standard. So that was interesting. But it came in, and it's evidence before this jury that this jury can and will consider in making their verdict.
So claws, if you want to go that way, and possibly the teeth as well.
And if there's a pointer up there, would it be possible to direct the jury to the injuries that you're referring to on the screen? There should be a little laser pointer up there.
I don't know that I see one.
It's not there.
Yeah, for sure.
They're all consistent with scratch marks in the sort of the more generic sense of whether it's the paws or the teeth, they're going across the skin rather than going straight into it. So they're all of these marks are generally consistent with, if you want to call them scratch marks. So I don't know if this will work on the screen, but you've basically got what looks like there's one pair there with possibly a third one in the middle. There are two very clear parallel marks there with another one fainter in the center. Then you have, going closer to the elbow, you've got another 2 or 3, whichever way you look at that. But at the elbow itself, you have, that's that part of the elbow there is what I would think is the most likely candidate here for a bite mark.
Guess who else said that? Dr. Russell. What's also really important in evidence? For it to be consistent. And the defense's evidence was pretty consistent. The Commonwealth's not very consistent.
Because it has something of the configuration of the outline of teeth. And then the ones on the forearm are a little bit less obvious, but they're still consistent in general with, I would say, claw marks or maybe from the teeth.
Dr. Sheridan, if you assume that the decedent was standing with his arm extended in this manner, and he was struck with the rear taillight of a 7,000-pound Lexus only on the arm, such that it spun him around and propelled him 30 feet, do you have an opinion as to whether or not these arm injuries are consistent with that scenario?
Objection.
I don't see what's like that.
So they go to sidebar, they take their morning break. And again, she's asking it where it's like, guess what? That doesn't make any sense. Now, can this expert explain to us why it doesn't make any sense? Yobi said, can you imagine a scenario where the jury votes guilty? You mean what the aftermath will be like? Well, we'll talk about this more as we get our votes happening. And then also ask, are you playing in the Rocket Mortgage Classic? I wish. Just Reset. Are you going to cover Turtle Boy's assault videos regarding his witness intimidation case? I have not seen those. I'm not sure what his witness intimidation case is. I know that he had to sit out of the courtroom for some of the witnesses. I assume you're discussing that. Yobi also maybe add some context. In Turtle Boy's live yesterday, Colin Albert went up to Turtle Boy and said, no one is scared of you. Chris Albert also, this is happening right now in the middle of the trial. Chris Albert also said he was going to mop the floor with him. Can this be used as evidence in Turtle Boy's case of witness intimidation? Absolutely. Absolutely. That's wild. Casey, why wouldn't the judge let the experts provide their conclusion? So she did, but you can't ask him the ultimate question in the case to make the conclusion that this didn't happen, but instead she could say, or they can say it's inconsistent or it's not likely to happen or it's not consistent with what I would expect when they're hit by a motor vehicle. They can't say Karen Reed didn't hit John O'Keefe. They don't allow experts to opine on things like that, especially because they don't know. As a matter of fact, what they're doing is using their expertise to testify about what is or is not consistent or possible or likely to happen. Flo, if the FBI knows it wasn't Karen Reed, why let this go to trial? So I don't know that the FBI has said they know it wasn't Karen Reed. We don't know specifically what the FBI is saying, but I have a lot of thoughts on this point when we get to the FBI hired witnesses. Yobi, do you think the jury figured out the FBI hired the witnesses? There were definitely some hints dropped, and we'll get there when we get to the FBI witnesses. I'm going to skip this sidebar and get to where he actually answers the question the way the judge lets him answer the question. Here we go.
In a loud voice.
Thank you. And Dr. Sheridan, I'll ask you to also just keep your voice up for this question.
I'll try.
Assume the decedent was standing with his arm outstretched like this and was struck by the rear of an SUV, only in his arm at 24 miles per hour. Are the injuries in Exhibit 19 consistent with that scenario?
No, I do not think so.
Can you describe that?
So again, she said, instead of saying, did John O'Keefe get hit by Karen Reed? Basically, she's like, let's just say in a hypothetical, a man that was 6'1", 220 pounds was standing like this and got hit by a car. Would you expect it to look like this? He's like, no. Very simply, no. And guess what? Neither do I. Neither have I the whole time. That's been my common sense thought. Now we have expert testimony and evidence of that. That's huge. That's huge.
Well, as I think I've already mentioned before, one thing that's not there, that should be there, given that idea, that scenario, is there should be bruising, at least bruising, if not perhaps even more than that, but bruising for sure. Secondly, the appearance of these injuries, their pattern, if you want to just call it that, the way they're distributed, doesn't seem to fit the idea of the rear of a vehicle being the impacting object.
Pattern and the lack of bruising or fractures. Now, the pattern stuff, I could imagine some weird stuff happening and maybe potentially you get some kind of pattern based on the rub, based on the scratch, whatever it may be. But the lack of bruising and broken bones, and again, maybe this is unfair because I handle a lot of car accident, truck accident, pedestrian accident cases. This never made any sense to me. You know, I thought maybe the Commonwealth's case was going to be he got hit in the head with her car, or they had some proof or evidence that he hit the asphalt, the street, something like that. Like we've heard these hypotheticals, but they did not say that. That was not Trooper Paul's explanation. They had no proof of that. They had no expert testimony of what actually happened. We think that maybe he was holding his hand out and he was projected and he landed in the grass and the grass might have been frozen. That's the best they could do. They didn't even, so some of Lally's, right? So in Cross, and this is where he missed the boat on Cross. And it's hard sometimes for state attorneys or district attorneys to do Cross because they start falling into the trap of acting like defense lawyers and poking holes in some of the defense's theories and trying to provide reasonable doubt. Now, the problem is if you provide reasonable doubt with things that you have not proven, it doesn't really help your case. If you provide reasonable doubt with what your experts testified to, what your witnesses testified to, what you've proven, then that helps because you can eliminate the reasonable doubt with the truth and the just evidence if you have it. But if you're just throwing things against the wall, you're missing the boat on what you should do as Cross as a prosecutor. He said he would have been immediately unconscious and unable to walk, which is important. He didn't stumble around and end up where he ended up. He asked, or Little asked if it was consistent with falling on the grass. He said no, maybe a hard surface, and maybe not even a hard surface if there was snow patting the ground. He has investigated also, guess what? Car accidents, animal injuries, and fights. So let's hear what he had. It's not consistent with a car accident. It is consistent with an animal injury. Let's see if it's also consistent with fights, the head injuries.
I'm going to give you estimates here, but over 1,000 would have been homicides. Of those, probably maybe a fifth, so about 200, would have involved blunt force trauma instead of, for example, a firearm or something like that. And in those cases, and of course, yeah, okay, so all of those and other cases involving sharp force, homicides involving sharp force may have evidence of a struggle as well. So it's in the hundreds, yeah.
In your expert medical opinion, are Mr. O'Keefe's injuries consistent with a fight or a physical altercation?
In a general sense, they can be. They could be, yes. He had, I alluded to it just briefly before, but the head injury, the major head injury I've described, but he also had a laceration over his right eyelid. He had some scrape marks on his face. He also had some bruises on the back of his right hand, which that kind of injury on the hands can be what we call a defensive injury. In other words, an injury that occurs when you're protecting yourself and you're hit hit either with another fist or with a hard object, and you're protecting yourself. So I would say that some of these findings I've just mentioned are consistent with the possibility of a physical altercation. Yes.
Thank you. I could have one moment.
Sure.
Not consistent with motor vehicle accident. Consistent. Hold on one second. Sorry, I just got kind of an important text. Sorry. Not consistent with motor vehicle accident. Consistent with animal injury to his arm, and consistent the head injuries with a fight. Honestly, it's starting to feel like something I said I didn't think was going to happen and I didn't think was happening, but the defense is starting to prove their case more beyond a reasonable doubt than the state is. Now, I don't think they've proven, who did it, things like that, but they're starting to prove that maybe this really wasn't Karen Reed that caused these injuries. And again, from somebody who knew nothing from the beginning of the case, and I'm just coming and listening to the evidence, the state had 20 7 days to prove their case, and the defense is doing theirs in 3. And we'll see by the end of the case what I think, just from my perspective, what I think they proved. And Yobi said, Din said you're crazy for thinking the witnesses are credible. Well, here's what's great about it. There's different people on a jury that come together, and each one of them has to make their own decision and their own vote. And they get to look at witnesses, and they get to determine whether they think a witness is credible. From my perspective, I don't really think this guy differs too much from what the Commonwealth experts, the medical examiners, and their medical experts say either. I think he was willing to kind of walk out on a limb a little bit more than the Commonwealths were. And guess what? What he's saying also lines up with common sense. So when you lock into what I feel like I already know to be true, and you give me that evidence, a lot of times that'll confirm it, whether right or wrong. And the same thing will happen with juries a lot. Francis said, Turtle Boy said the other night that he watches you. And yes, Turtle Boy was assaulted last night by the McAlberts. The McCabe's and the Alberts. It was wild. Yeah, I've heard mixed things about, what Turtle Boy says about me, and I get it. I'm not everybody's cup of tea. But the way I look at these trials and the way I go through it is I try to dissect and think about what the lawyers and the judges are doing, how I'd handle witnesses, how I'd cross witnesses. Even in a loser case, sometimes you got tough cases that you got to try as lawyers. And everybody looks at cases differently, and I get there's a lot of passion. And, obviously I've heard witness intimidation and whatever stuff going on, and potentially people going to jail as an ancillary part of this case. So I know there's a lot going on that I am not fully in. And I'm sure that's going to continue even after the verdict. Christy Allison, 2 McAlbert family members assaulted Turtle Boy in public on video last night in Canton. That is wild. Yobi said, lost bet with wife. You didn't notice what's on TV. Honestly, if you're talking about golf on TV on a Monday, I don't know. No, I did not notice on TV. Between working and watching these cases, that sucks up all my time. Tiny E, do you think when Lally says to these experts, now you've testified earlier under penalty of perjury, that will rub the jury the wrong way? He's clearly trying to say you lied under perjury, under penalty of perjury, but he doesn't ever end up getting there, which is the problem. Does Lally have to be careful about objecting too much? At some point, does it start to sound to the jury as though he's just afraid of the experts? So I don't really think he objected a crazy amount. The problem is, and I think what you picked up on, is when he was objecting, he didn't want them to testify to the ultimate issue. Now, they're not supposed to, but then when they were able to ask it the right way and still answered, it's very obvious. And now it's been highlighted by Lally's objection that their answers are very bad for the Commonwealth. Very bad. Nicole, question about Yannetti and Jackson. Is it typical for attorneys from different firms to work together? What is the reason? Just curious. I wouldn't say it's typical, but it happens from time to time. Usually you want to build a really big defense team, and you want multiple firms, different resources, different specialties potentially. You want a local feel, and you want, the big shot California, big city lawyer sometimes. It all depends on the client's preference and funds, obviously. Can too many Commonwealth objections irritate the jury? Maybe there was too many today for a jury's liking. It didn't bother me. I didn't feel like there was way too many objections. SM, can having too much of a defense story ever hurt a defense? Absolutely. Seeing Karen Reed as guilty people spending a lot of time poking holes in the defense, which is ironic, but does worry me. Absolutely. And like we said from the jump, creating a burden for yourself can be very problematic and difficult for the defense. So, we'll see if it comes back to bite them. I got to be honest, I don't think it's going to. But we're going to keep listening. So we're going to get to the first cross of the day. Lally basically confirms that he agrees with a lot of the Commonwealth experts' testimony and cause of death, things like that. Explains the difference between postmortem and antemortem. He is saying you can't be sure what kind of animal it is. But again, that's playing defense lawyer. You can't be sure what kind of animal it is. It's yeah, but I don't need to be sure, because if it was an animal, then it wasn't Karen Reed, right? Because again, and all the theories that she could have hit him, an animal could have come later. Sure. A million things could have happened. The problem is the only thing we can consider as the jury is those scratch marks came from the taillight of Karen Reed's SUV. That's the only thing we can consider. If you think something else happened and some other animal came and chewed up his arm after he was on the ground, that's not what the Commonwealth has told us. So you cannot vote guilty. They're just making crap up if that's really what happened and you believe that that's what happened. You have to go with their theory and their proof and their evidence, and if you think it's true, you vote guilty. But if you're making up other things to fill in holes for their case, that's reasonable doubt. You have to vote not guilty. He asked, so this was interesting because I got a note here. He asked if the doctor looked at Chloe's past attacks and bite marks in those cases. He made sure to say it was with an animal and then she ended up biting a person, whatever. But he said it in a way where I wrote in my notes, is Lally going to call a dog bite expert and try to compare Chloe's other bites with this bite to say that it's not it? And then I was like, wait a second, didn't Lally bring up an article that said that was junk science, basically? I was like, this is interesting. Is he setting up a rebuttal? I want to see if the Commonwealth's going to have a rebuttal. That was my note then. Hindsight, we know they don't have a rebuttal, which completely makes that fall flat. Did you look at the bite marks of Chloe? Did you look at him on the other case? He cannot argue that those bite marks are inconsistent. He cannot argue her jaw was twice as wide when she bit the other person than when she supposedly bit John O'Keefe. He cannot argue that. That is not in evidence. So the little inference he was trying to make with that cross-examination question fell flat. Then he goes through the DNA, matching John O'Keefe's hair on the back of the bumper and the glass and the particles in John O'Keefe's clothing. He went through that and basically all of the witnesses today. He did talk about how most of this guy's experience are with children getting hit by cars. And he said, would you say for sure you'd get bruising? And he said, for sure, and maybe fractures too. He didn't know or doesn't remember that the cocktail glass was found near John O'Keefe's body. I don't know why that matters, right? He's looking at the injuries. He's trying to figure out whether the car could have caused those injuries. And then Lally asks some interesting questions near the end that we're gonna take a listen to.
And there's an additional, the ones on the lower forearm, on the forearm, I should say, are harder to figure out. But it looks like 4, maybe 5 separate.
4 or 5 separate sort of swipes, whether they be with mouth or claws or whatever.
Yeah, that's correct.
And so is it your testimony that it's not possible that Mr. O'Keefe received that from some part of the motor vehicle, or glass shattering, or shattering from a taillight, or any sort of metal pieces underneath contained within that taillight housing as far as his interaction with the vehicle?
They don't look remotely like that to me.
So it's not.
Why are you asking that question if you're Lally? Like, if you have a rebuttal, fine. If you don't have a rebuttal, do you want the jury to hear from this guy, from you? Sir, let me get this straight. Are you saying it's not possible that John O'Keefe was hit by a car? And he says, it doesn't look remotely like that for me. But then again, I've only done 13,000 autopsies and a couple thousand motor vehicle accidents. Why are you asking that question? I don't get it.
Not possible. Is that correct?
In my opinion, no.
Just to confirm, it's not, you're saying it's not possible. In my opinion, no. And yes, I'm an expert, and I just explained all of my expertise to this jury before you asked me that question.
You were asked about.
I'm going to jump ahead a little bit more to when they start talking about the eye injuries and what those could have been.
Don't forget, it's in the same area where they got the other injury, and it's a little bit hard to figure out whether how much hemorrhage, how much of that black eye could even be from related to the laceration, because you've got 2 possible explanations for the black eyes. One is the skull fracture I already mentioned, but that doesn't rule out his getting an impact as well on the front. But there's no way to separate them.
As far as around those minor lacerations that you're talking about, you didn't observe or see any record of any bruising or any broken bones in those areas whatsoever?
No, the main one that I was relating to when I spoke about the altercation question was the laceration on the eyelid. That's not related to the head injury that we've been discussing. So it's a separate injury, and it is from some kind of blow to the front.
The minor lacerations that you observe, would they be consistent with being struck by broken pieces of glass or broken pieces of broken sharp pieces of plastic?
If it was indeed a laceration, as it was described, then no, because lacerations by definition, although this is a term that's often misused, by the way, even by some doctors, but a laceration by definition is an open wound caused by blunt force, not sharp.
And what's interesting is I think that's what her expert said too. And I was like, how is it, because I'm dumb. I'm like, I'm not a doctor. How is it that these, sharp things? And he's like, no, when you get hit by something, even if it cracks and becomes sharp and it splits the skin, basically, that's from blunt force. So it can happen getting hit by a car, or it can happen getting hit by a fist. But these look like ones that are getting, like you're getting hit by a fist, basically, is what he's saying they're more consistent with than getting hit by a car. It doesn't make any sense for them to look like they got hit by a car. And Lally confirms it 3 different ways. And the guy's like, yes, some of the swelling and the pooling of the blood is what the black eyes are from, but it's hard to tell because some of it could also be from connected to the split in the front of his face.
So blunt force, as far as what I'm asking is it possible that the lacerations to his face were caused by a blunt object? that then shattered and caused the lacerations to his face.
I find that hard to imagine. I find that very hard to even conceive of.
So it's not conceivable, is that what you're saying?
To me, no.
Hold on.
Then shattered and caused the lacerations to his face.
Yeah, because he's saying shattered, meaning got sharp and then cut his face. And I think this guy's, and again, maybe I'm confusing it, but this guy doesn't think the light shattered and then scratched his face, which guess what? Here's the annoying part. Lally doesn't think that either. That's not what the Commonwealth said happened. The scratch marks couldn't simultaneously scratch John O'Keefe's arm and scratch his eye. So what are you talking about? This is where he loses me completely, to where I start to think Lally doesn't even believe his own theory of the case.
I find that hard to imagine. I find that very hard to even conceive of.
So it's not conceivable, is that what you're saying?
To me, no.
And from your
Okay, then on redirect, he shows a little bruise because, Lally, of course, had to make a point that there's a bruise below the neck, and they show the little bruise and whatever. Okay, before we get to Dr. Wolfe, let's answer some more questions here. Ashley said it's an easy not guilty, reasonable doubt with everything. In my opinion, cover-up wasn't proven, but most plausible. What other explanation is there for all this sus stuff? So one other explanation is some people believed it really was Karen Reed, and they made sure to make all the evidence point to her. That's one other. That doesn't have to necessarily be a cover-up. They did the wrong things for what they thought was the right reason. Still despicable, still horrible, but that is kind of another explanation. John, can you explain the difference in definitions of not guilty versus innocent? I believe them to have different meanings, absolutely different meanings, just my opinion. Innocent means you did nothing wrong. You committed no crimes. Not guilty means you are either innocent. It encompasses innocent because the jury doesn't decide innocent, but it's innocent. You're either innocent of the crime or it's not proven, where maybe you did do it, but the state did not meet their burden. Either they didn't prove it at all, they didn't prove it beyond a reasonable doubt, or they just proved it like preponderance of the evidence that it's more likely that it happened, but they didn't prove it to the burden necessary to convict. That would be the difference. Jen, it felt like Lally was trying to offer alternative explanations with the last expert, with most of the experts, as we just saw. Well, maybe the taillight scratched his eye. Example, sideswiping the prosecution already has their theory. Why on earth give the jury possibilities? I don't get it. Oh boy. What Lally did with the sideswiping, I thought was one of the worst moves he's made the entire trial. These next two experts were truly a class on what not to do on cross-examination. And now we've talked about this, and this was a good example, and I like to learn and watch, and we get to learn together. When I say be careful with experts, I don't mean don't ask them a question. I don't mean, sir. I mean pick a couple points you know you're going to make, get in and get out. Don't argue with them with stuff where they're going to make you step in it. They're going to make you put your foot in your mouth, and they're going to take a softball and hit a home run with it when you have the ball, when you're up to the plate, whatever it is. It's like, that's what you just can't do. And Lally did it over and over again today. Yobi said, my TV and my profile picture is you golfing? No way. Shut up. That's awesome. It's like this big on my screen, so I can't really see it. But that's pretty crazy. That's funny. S. Crook, thoughts on Karen Reed not taking the stand? Do you think this helps / hurts her case, or does it not matter at all at this point? I think it was the easiest decision in the world after hearing these three witnesses to say Karen Reed doesn't need to take the stand. Lori, will the jury be sequestered until a verdict is decided upon? I have not heard that. If anybody else has heard that, let us know in the chat. Breezy, Pita, now that all the evidence is out, are you guilty or not guilty? Not innocent versus guilty. I'm going to talk about this when we do the poll. I will talk about this in today's video when we do the poll. Okay. Let's get to Dr. Wolfe here. Very impressive background. He's the director of this company with Accident Reconstructionist. We know all that. We heard his background in voir dire. Now, to Yobi's question earlier, do we think the jury picked up on the fact that the FBI hired these witnesses? I want you to hear how he explains kind of who they work with and the little breadcrumbs that get sprinkled.
The entire accident reconstruction format for ARCA, correct?
That is correct.
What sort of contracts does ARCA routinely engage in?
So we do a lot of work in civil litigation. So we work with insurance carriers, law firms, but we also consult with and do projects with the federal government as well as
insurance companies and law firms. Those are the cases I'm involved in. Insurance companies on the other side. Law firms would be my side. And guys like him are in a lot of our cases, not all of them, but a lot of our cases. A lot of our cases, by the way, just a side note, liability is not disputed, like the other person admits fault, we usually argue about what the case is worth. So then we wouldn't need him. But if there is liability fault, like who's at fault, who hit who, whatever, then we'd get an accident reconstructionist. But he also says the federal government. Now, Jackson does something that's incredibly ethical, I thought, and goes back and says, talk more about the Department of Justice and what you do, or I think he said Department of Justice, whatever, Department of Defense, Department of Defense in the military and how you help them. So he just makes sure they don't, try to pick up on it there. So I thought that was really ethical and he didn't need to do that, but he did. But he said the federal government. And later Lally says agency. So I think it's possible that Yobi, they're picking up these breadcrumbs.
The National Hockey League on player safety. So we're involved in a number of research projects as well.
Of course, he drops National Hockey League because what do I always say? Jurors usually love experts that work with professional sports. They get into his prior work, applying science and math to collision. This guy is an accident reconstructionist. This is what you want to hear. This is who you trust, okay? And what I'll tell you is, a lot of times these guys don't sway me in cases because I know in so many of my cases, I'll get somebody who tells me, yes, you're absolutely right. The other side will get somebody who tells me, you're absolutely wrong, Mr. Tragos. And so then I'm like, crap, how do these guys say the opposite things? We've talked about this. They're both getting paid by each side. I don't want my guy to lie to me. If it's a bad case, just tell me it's a bad case. But in a case where we have Trooper Paul, who literally has absolutely no mathematics, scientific, physics, any backing to any of his opinions, none of them make sense. He's making stuff up on the fly. He gives an example that logically you just wouldn't understand. He's giving all sorts of excuses as to why he can't do the formulas. And you have the juxtaposition with this guy and the next expert who are going to scientifically explain to us what already makes sense in our mind. And guess what? They weren't paid for by the defense. This might be the single most case an accident reconstructionist has swayed my opinion. And I do this, not even less than 50% of my cases, but a lot of my cases have accident reconstructions. Biomechanical experts, how the body moves, how an injury could occur based on how the body moves. Because the other one was next to nothing and he wasn't paid for by the side that likes his testimony. That makes a huge difference for me. Now, I bring some baggage into this, right? Because I sit on most cases where there are two, highly qualified guys just like this guy, and they say the opposite things. So when that doesn't happen, then I'm like, whoa. And Jackson wants to make sure the jury knows the defense didn't pay this guy. And not only did they not pay this guy, but his reports that Lally's going to reference on cross, guess who had access to them? The defense and the Commonwealth. Neither side paid them. They were hired by a third party, and they might never have testified in this trial. Members of the jury, you may never have heard what these guys had to say if we didn't call them, because the person over there that's supposed to be fighting for truth and justice just left this out, just like they left Lucky Laughlin out, just like they left all the people out that told them this couldn't be Karen Reed. They didn't want you to hear this. That's what Jackson's trying to say with these questions here that we're going to listen to.
Is capable of recording. And specifically, it was looking at what triggers a sudden braking event. So we were able to determine that those triggers, the sudden braking event is triggered when a driver, I should say the vehicle,
Jackson,
reaches...
May we approach?
Sure.
You are unmuted.
Now, you're,
Yes, you can
thank
move
you.
on.
You've been qualified in other courts to testify as an expert in the area of accident reconstruction. Is that right?
Yes, sir.
You were not hired by the defense in this case, correct?
That is correct.
At the time you did your expert review, Dr. Wolfe, and your consultation, you and I had never met.
That's correct.
You did not know who I was.
I did not.
You'd never met Ms. Little.
No.
Ms. Giannetti.
No.
Matter of fact, you'd never heard of this case.
That's correct.
You were hired by another agency not connected in any way to the defense. Is that right?
Correct.
And not connected in any way to the Commonwealth. Is that right?
Agency.
Correct.
So your analysis and your conclusions and your opinions are completely independent of the defense and the Commonwealth in this case. Is that right?
Objection.
Sustain, Mr. Jackson, you can ask it differently.
When you did your analysis and conclusions, well, let me ask it this way. You finalized your report, you and your team, correct?
Correct.
That report is contained in a multi-page document that was submitted following your analysis and your opinions and conclusions, right?
Correct.
The defense didn't have anything to do with that, correct?
Correct.
You'd never met us, didn't know who we were when you did this.
Correct.
You'd never met Mr. Lally, didn't know who he was when you did this.
Correct.
So your analysis, opinions, testing, and conclusions were requested by completely separate agents.
That is correct.
Goes without saying, but I'm going to ask it anyway. You haven't been paid by the defense,
You have not paid us anything, no.
and you don't work for us.
That's correct.
As a matter of fact, I've never
Again, by the way, like this is so unusual and it probably strikes me more than most people, but I cannot explain to you how unusual this is. A defense lawyer calling an FBI hired expert.
You have not paid us anything, no.
and you don't work for us.
That's correct.
As a matter of fact, I've never asked you specific questions about your testing before today.
That is correct.
So how smart risky, ballsy, but how smart of it was the defense to not prep these witnesses? Because they could have had a call. Let's talk through your opinions a little bit. Oh, no. Au contraire. Because they asked it to a lot of the other witnesses for the Commonwealth about the prep and talk time with Lally. When's the last time you met with him? Blah, blah, blah. Because they were setting up for what they knew they had. I didn't know if they talked to these guys or not, right? Jury didn't know. But when this guy takes a stand, it's like, this is the first time we're talking through this stuff. I'm going to learn it with the jury. I've read your report, but we've never talked about it. So let's see what happens. Let's take this ride. This was like, again, this is really sad that a life was lost, an investigation was botched. It doesn't feel like his family is going to know what happened at the end of the day. Maybe they feel like they know what happened and they're going to think it's an injustice, whatever it may be at the end of the day. Maybe they'll feel like it's justice. I don't know, depending on what happens. But this is good court, if I may say that. This is good court. It's unbiased. It's not bought and paid for. It's not slimy. It's a guy hired by somebody else with a lawyer just asking him questions. Wouldn't it be nice if it was kind of always like this?
Your work product, the report that you provided, was provided both to the defense as well as the Commonwealth. Is that right?
That's my understanding, yes.
And you were equally available to both sides.
In terms of them reaching out?
Correct.
Yes.
And I called.
Report was given and produced to the Commonwealth and the defense. The jury heard that. You were available. Either side could have reached out. Either side could have called you to the stand. This is evidence now. You absolutely can argue that. Sometimes the judge, and there's certain sticklers about you can't argue this, you can't argue that about trial strategy or who they did call or didn't call or whatever it may be, especially if there are time constraints and you can't hold it against. Not here. This is record evidence. If the judge sustains an objection in closing, the defense should pound the table, and I'm sure they will. Say, Judge, these are facts and evidence. That guy testified to it over no objection by Lally. So we should be able to argue this in closing, and I think they should and they will.
Yes.
And you were equally available to both sides.
In terms of them reaching out?
Correct.
Yes.
And I called you ultimately after receiving a report, asked if you join us and testify, correct?
That is correct.
Were you and your team asked to undertake a review for purposes of accident reconstruction of the case that's now pending before the court?
Yes, sir.
Was your team asked to do this by the agency that ultimately retained you, not us?
That's correct.
Who at ARCA was assigned to the team who would ultimately undertake this job of accident reconstruction?
It was myself, Dr. Andrew Rentschler, and Scott Klein.
What was Dr. Rentschler's role in this case, as it's distinguished from your role in the case?
Certainly. So Dr. Rentschler is a biomechanical engineer, and ultimately he assessed whether or not there was a mechanism for the injuries of Mr. John O'Keefe.
And what was your focus? If he's talking about the injuries to Mr. O'Keefe, what was your focus in your reconstruction and your analysis?
I would simply say it was looking more at the damage to the vehicle.
All right, so that's kind of the differences in their testimony. And then we're going to get to basically his opinion here. So this is his opinion. We're going to listen to a lot of it. We're going to pause, talk about it, talk about what we like, what we don't like, what lines up, what's consistent, what's not, what we think the Commonwealth could potentially pick apart.
Or deformation that you were able to glean from your review, the photogrammetry, damage to the Lexus, the bumpers, the panels, the quarter panel, the sheet metal, anything like that?
No, the rest was remarkably intact.
Is it common in vehicle pedestrian collisions that there's some sort of bumper displacement and or sheet metal deformation that's concomitant to that?
Absolutely. Assuming a pedestrian is positioned in a normal upright position, you certainly would expect to see damage to the bumper. In a lot of cases, what happens is, the bumper is just clipped on. So again, the force of that impact will oftentimes cause the bumper to kind of become unmounted or unclipped. You certainly could see deformation to body paneling, such as the liftgate or the quarter panel as well.
Is that especially true?
You'd be surprised how low impact of accidents I've seen damage the bumper or damage cars more than this. Besides the light just exploding, the rest of the car, the damage done to it, seems very either low impact or like it didn't hit anything.
At higher speeds, meaning above 15 miles per hour or so.
Oh, absolutely, yes.
Was there any apparent damage to the Lexus that appeared consistent with any kind of pedestrian interaction that you saw?
No, it was really confined to just the taillight, a very isolated portion of the vehicle.
During your review and your investigation, did you note information concerning items that were supposedly found on the bumper?
Yes.
What was that?
I believe it was noted there was 2 apparent glass fragments located on the top bumper cover.
What's the significance of the presence of those items or the lack of materiality of those items in your view?
Well, again, I think it's going back to the scene evidence. Again, we knew that there was glass fragments, what appeared to be from a drinking glass, at the scene of the alleged incident.
Is there any glass consistent with the glass that was supposedly found on the bumper in the taillight housing, the taillight mechanism, anything from the car, the Lexus, that would account for that glass?
Okay, I think I understand. So the taillight itself is not comprised of any glass. It is all plastic. So that damage, or I should say that glass on the top bumper cover could not have come from the right taillight.
Now, based on your review of the information that was provided to you, did you undertake any testing of that vehicle? I'm sorry, any testing concerning the damage to the vehicle?
Yes, sir.
All right, can you describe what that testing was?
So we performed, again, this is with Dr. Rentschler and I working together on this again. We performed projectile testing to the tail lamp with a drinking glass as well as a hybrid head form.
Let's take those one at a time. How would you describe the drinking glass test?
Certainly. So again, from our review of the evidence, we knew that we had an isolated portion of damage to Lexus confined to the taillight. So we know that we're dealing with potentially a small object that could have created that. Looking at, again, the evidence in terms of the scene photographs, we know that we have a damaged drinking glass at the scene in the vicinity of the fragments of the taillight. So the theory that Dr. Rentschler and I put forward is potentially an individual threw this drinking glass at the back of the Lexus, causing the taillight to fracture.
I'm going to interrupt you right there. You and Dr. Rentschler formed that theory.
So what's interesting about this too is, so they're going to talk about a theory that, again, I don't think happened, but a theory that's possible. But the important thing I picked up there that he said was it looked more like the damage to the taillight happened from a small object. And he's going to talk about, potentially they talked about the cocktail glass being thrown at the taillight, causing the taillight to explode. What are some other small objects that could have caused this? I think the defense wants the jury to think a hammer by the cops creating this cover-up. I'm also wondering what the FBI thinks. It's unlikely it was the cocktail glass since it doesn't look like it shattered that way and it ended up on the body of John O'Keefe. It is possible, obviously, that he did throw it at her car. It was on the ground. After the Alberts did whatever they did and put him in the snow, they moved the cocktail glass. Oh, sure, all of that's possible. But the fact that they think the damage to the taillight is consistent with a small object could mean a number of things in the other investigation.
And wanted to test that theory, correct?
Yes.
You were not told that theory by the defense because you've never met us.
Correct.
You were not told that theory by the Commonwealth. You've never met them, correct?
Correct.
Your theory was the product of simply having some facts extant in the data that a broken drinking glass, a broken taillight, let's put them together and figure out if the drinking glass could be responsible for the taillight, vice versa.
Absolutely, yes.
And that was your determination of, well, we were given instructions to reconstruct this. Let's look at every single angle, correct?
Absolutely. And I will note, as part of the engagement with the entity that retained us, we were asked not to do any outside research or investigation of the case. It was to be based solely on the evidence that we were provided.
Okay.
So it sounds like the FBI was like, here it is. Have at it, folks. Tell us what happened. Here's all the evidence. You tell us what happened. Now, obviously, there's a guy laying on the lawn, so they know that's one potential option. But this was the one they found made more sense, that somebody may have thrown a cocktail glass to hit that taillight. And I think it's pretty clear. We haven't heard the defense say that once. So if the jury's listening closely, they're like, yeah, he didn't get that from the defense. So clearly he just came up with that as a possibility. This guy is truly independent.
As a matter of fact, and importantly, while you were doing your testing, had you ever even heard of the Karen Reed case?
No.
So
Never heard of it. How about let's compare that to the Commonwealth's investigators. You think they'd ever heard of it? You think Proctor or his boys had ever heard of it? Had any thoughts on the Karen Reed case? And that's the point. He admitted it. They all hated her. They all thought she did it. They all wanted to make sure she went down for it. Compare that to this guy. And then compare their ultimate opinions. I have had ARCA on cases in different ways. I have never hired them myself as an expert. We've had them sometimes on other cases or just provide reports that ended up testifying. that have helped things get resolved kind of on both sides. So in an ancillary way, not a lot directly. They're not like a go-to for me or anything, but I do like them. Maybe I'll reach out to them now. Who knows?
Getting back to that testing, and I interrupted your flow, you were looking at whether or not the glass could have produced the damage to the rear taillight that you saw, correct?
Correct.
And what did you do in furtherance of making a determination about whether or not that was possible?
Certainly. So myself and one of our lab technicians at ARCA, we designed and developed a pressurized air cannon. So it was capable of firing a projectile such as a drinking glass at the taillight. So essentially, you think of it kind of as a giant cannon, but it had a barrel, and then there was a valve that would open rapidly, and directly behind that was a pressurized vessel. And depending on the pressure, the PSI of that vessel would determine essentially the speed at which that glass would be projected into the taillight.
So you literally built a cannon?
Yeah, it's pretty awesome.
Pretty cool job.
Pretty cool job. You know, the jury probably loved that. A lot of people on Twitter love that. I don't really care. I don't really know how it affects this case or helps this case or makes any difference. But when the jury likes your expert, that's a good thing. Just like when we pick a jury, if I feel like the jury likes me, that's cool. Like, does it mean we're going to win? No, but it's better than them hating me. It's better than them being like, this guy's so boring, get him off the stand, right? So if you can get that connection, it's usually a pretty good sign.
Tell me what the results of your testing was with this pneumatic cannon that would fire the drinking glass.
Certainly. So we performed 2 different tests in terms of speeds. The target speeds were 30 and 40 miles per hour.
Why was that?
Well, so with consultation with Dr. Rentschler, he indicated that that is a reasonable speed at which an adult male or an individual for that matter could throw a drinking glass at the taillight.
Had anybody up to that point, anybody told you any specific, let me see if I can rephrase that. Had anybody indicated that there was any evidence whatsoever that John O'Keefe had thrown a drinking glass at the taillight?
No.
Was this another example of you and Dr. Rentschler and your team just exploring sort of every possibility and working a little bit in the blind?
Objection.
Sustained.
What was the reason that you decided, or you and your team decided, that you wanted to approximate how a grown man could throw a glass in a taillight?
Well, I think we wanted to have an understanding is when a projectile such as a drinking glass interacted with the taillight, would we get damage on the test taillight that was consistent with that of the subject taillight?
Understood. So based on your theory, were you able to approximate the damage on the taillight?
Yes.
Describe that for us.
So as I mentioned, we ran 2 tests. The target speeds were at 30 and 40 miles per hour. And there was a little bit of variability in terms of what our target was and what we actually achieved. So the achieved speeds were at 31 miles per hour and 37 miles per hour. So there's just depending on how the glass leaves the barrel and some of the rotation can affect some of the speed or ultimately the end result speed to that. So what I will say.
Anybody ever played in like a charity golf tournament where they have the cannon where they shoot the golf ball? That's what it reminds me of. I wonder how many times they had to do this. I wonder how many times they missed, how good the aim is. So many questions I have about this that they didn't get into, which they didn't need to. It would have been boring, but I'm just interested in myself. And they talk about what the average like miles per hour somebody could throw a glass would be. And I just found that to be interesting as well. Bride of Frankentruck. Thanks for the comment. I do my best. And I know some people hate that. And some people think it's like pandering or like leading people along or whatever, but that's what jurors are supposed to do during a trial. They shouldn't come to a conclusion after one witness and then just like shut down and stop listening. And they should also not know everything that's happening in the background of a case. So I try to make clear what the purpose and point of this channel is and what we try to do. Now, there are some cases we know a lot in the background. And even then we say like, we know this, but the jury doesn't. So we have to keep that in mind as we go into it. In this case has had so much passion and just like ferocity behind it from both sides that I think it's hard for people to put that out. And I understand once you think you know stuff and you come into a case and you think you already know the outcome, it's hard to think or understand how somebody could view it from the lens that I'm viewing this trial from, which I really have from the beginning tried to do. And now that the case is pretty much over, I've got a pretty good and firm stance of where I'm at.
Though is that with the 37 mile per hour projectile into the taillight, we noted and observed that there was damage that was consistent with that of the subject tail lamp, and that the test tail lamp had the majority of the outer lens fractured and missing, broken into pieces, as well as some underlying damage to some of the internal components as well.
Are you saying, well, let me ask you a different question. You were able to replicate the damage to the taillight using a pneumatic cannon firing the glass at 37 miles an hour directly at the taillight, correct?
Correct.
All right. And that would also shatter the glass too, correct?
Correct.
Did you do any testing about whether or not that damage to the taillight could be produced by a person simply holding a glass and being hit by the car driving in reverse?
We didn't do any testing of that, and primarily because, again, if we're looking at the arm and its total length, right? We only have a narrow damage pattern, which on the taillight, if you think about where the kind of where it meets the lift gate into where it starts to wrap around to the side of the vehicle, it's only about 6.5 inches in width.
All right. when you fired the glass into the taillight was static. In other words, it was not going to move. It was immovable at that point, correct?
Correct.
All right, so the glass is hurling through the air at 37 miles an hour and hits the static object that's resisting, and that smash is what produced ultimately the taillight damage that you were able to replicate. Is that right?
Yes.
If a person were holding in his hand the glass and the taillight were
Do you notice what they're doing here? They're talking about scientific stuff and different forces at different speeds and static objects and moving objects and what the result is without the mumbo jumbo that's hard to understand, and instead using descriptions and words we've heard through the trial that the jury knows what they are to get to the actual answer. I don't need to know what the number at the end of the equation is. I need to know what it means and what it shows and what it proves.
to hit that hand, the hand would not remain static, correct?
Objection.
Sustained. Ask it differently, Mr. Jackson.
If the taillight were the taillight would make contact with a person holding the glass, would that replicate what you did in terms of you're firing the glass into the taillight? In other words, are they apples and apples?
He's trying to say, obviously, if you're holding a taillight static, it's not going to make the same amount of damage as if you throw it against the light.
No, I don't think it would be the same.
Okay, why is that?
Well, as I mentioned earlier, again, the damage to the back of the Lexus, again, is confined to just that roughly, again, we're talking about the taillight itself, that 6.5-inch section in width.
Right.
So it's inconsistent with the total length of the arm, and certainly from discussion with Dr. Rentschler, inconsistent with the injuries to the arm.
So given everything in your investigation was revealed concerning this testing, are you saying that the taillight was damaged by John O'Keefe holding a drinking glass that was hit by an SUV?
Objection.
Sustained.
You, in all the information that you provided, you were not provided anything that suggested that John O'Keefe threw a glass at the taillight. Right?
Objection.
Sustained.
Very much.
That's just, yes.
Suggested.
So let's take a second break here, answer a couple questions. Deb N., do the jurors see the free care and read supporters as they go into the courthouse? If so, wouldn't that impact their ability to be impartial? It's hard for me to understand or know what the setup is like and who they're walking by. My guess is they're shielding them from all of that, hopefully. I don't know the answer, though. Yobi, Din said he doesn't believe you have a law degree. This is easily verifiable. Easily verifiable. SM, will you come to CrimeCon 2025 in Denver? I do like Denver. I don't know. I don't see myself going to CrimeCon, but I don't know. I've never been. I don't really know what it's about. I don't know. Din also said you aren't more of a 9 than a 10 in the looks. I assume you mean you are more of a 9 than a 10. Oh, ouch. Callie, what I can't understand, Peter, is why did the defense not bring up the 3 liters of blood missing / evaporated? Humans have 5 liters. That's 3 milk liters of blood. Where only 3 milliliters in 6 solo cups if killed on the lawn. Where? So I think Lank, and again, I'm remembering back weeks, I think Lank did say there was more, but they took what they took, basically. The Warthog, could the jury get confused and think they need to find out who did it versus reasonable doubt with how much the defense discussed third party, etc.? This is a great question, and let me tell you, this is a lawyer's job. In closing argument, I think it's going to be Jackson. He needs to make sure the jury does not get confused and think they need to figure out who did it. And I think he will. Amanda, love your show and coverage. Thank you. Why do you think McLaughlin is doing the closing? She has zero relation with the juror. So this is very interesting. I did not know this until I saw your question. If this is true, I'll tell you a couple things. Number one, Lally is not the best orator in the world, so it wouldn't really bother me. I don't know at all anything about her. But I have seen, and I think I did it one time with my dad, where he did the whole case and all I did was closing. And what you do is you basically say the 7th juror or the 13th juror. And all these people are doing all this stuff and the jury is sitting in the chair listening. And so you have another lawyer who's been doing the same exact thing as the jurors for the last 30 days, sitting in a chair and listening. And I'm going to tell you what I saw. That's how you can start the closing, right? You guys have been sitting in that chair for 30 days listening to evidence. I've been sitting in this one. Let me tell you what I saw. And then go through that. I saw these guys doing this and these guys doing that, whatever. So sometimes it can set up a theme for your closing. I don't know if that's what she's going to do. That's just what popped into my head when you asked this question. Beach Rando. Are we voting after closing arguments? So we're going to vote now. What I'm going to do is, before we get to cross here, John and Kelsey, whoever's going to put up the poll, I'm going to finish direct. Then we're going to put up the first poll. then when we get to the next witness, we're going to put up the second poll, and then we're going to redo the polls after closing arguments to see if closing changed your mind. But not yet. Joyce, Commonwealth didn't include manslaughter with jury instructions. Can the jury still decide lesser charge, or is that out? So I think, and I've seen some stuff going on Twitter about this. I didn't watch the charge conference, but I think what happened was they're going to do second degree. They're not doing the lesser includence of second degree, but they're still doing manslaughter while driving under the influence. So they still have the accidental charge, basically. They have the intentional charge. They have the accidental charge. I believe that's what they're doing. And then they have the leaving the scene of the accident charge. So I think they are still trying to get an accidental killing in there, regardless of whether they do the lesser included. ERN, do you think it's possible no one was there but Chloe? Still, I wonder why were they all protecting Colin? Also, B Jr. will never have a happy birthday again. That's sad. But also deserved if they really did do what some people are accusing them of doing. Paula Z, how can they believe Karen Reed did it and make the evidence fit when you have experts saying it was a dog bite on the arm, not a car? It's a good question. Amy, why was Lally asking questions like he understands science? The prosecutors need to do this. He did it badly. No. You've got to know when you have the upper hand and when you don't. And when you don't, just pack it up. All right, let's keep listening here.
Correct.
You also did some testing concerning a drop test. Is that right?
Correct.
Tell us about that drop testing.
Certainly. So again, through discussion with Dr. Rentschler, it was my understanding that Mr. O'Keefe had a skull fracture on the back of his head. So we wanted to do an evaluation of the interaction between the...
So Yobi Trice, they could have done that, but then they would have had to work with this expert and potentially pay this expert. Instead, I think it came off better that they just did what they did. The defense never asked them to do anything. And I liked that.
Back of a head. In this case, we used again, talking about that instrumented dummy again, we used the instrumented hybrid head form to perform a drop test to evaluate the forces of an interaction between a tail light from the Lexus and the human head.
What height did you...
Which is exactly what we were begging for with the Commonwealth witnesses. Do this kind of testing. What are you doing? Come on. Why don't we see this? And when I was saying what accident reconstructionists usually do, if you go back to that video and find wherever it is when somebody asks that question, this is what they do. This is what we were asking for: testing and numbers and equations and math and dummies and cannons. I don't think I said cannons.
Choose to perform this drop test?
7.5 feet.
Why'd you choose that height?
Well, if you calculate it through physics and the acceleration due to gravity, that would equate to an impact speed of 15 miles per hour at that height.
And what was the significance of 50 miles per hour?
Well, that was essentially kind of a starting point for us, if you will. So I will tell you that in reverse, 15 miles an hour is fast. I don't know if you've ever looked at your speedometer when you're pulling into your driveway, reversing into a parking stall. Most people probably don't go more than 5 miles an hour. So 15 miles an hour in reverse is fast, especially when we're talking about, it's my understanding it was nighttime. There was winter conditions, potentially wet or icy roads. So again, that speed is going to be what I would say on the high end for going in reverse. So also in addition to with respect to kind of just the nature of that speed, it's my understanding through discussion with Dr. Rentschler that at 15 miles an hour, you start to see significant injuries to the human body when it makes contact with a vehicle. And I think one last point is that we needed to pick a speed where, again, this is kind of just us brainstorming, where we would have damage to the taillight, right? It would fracture it, but it wouldn't completely obliterate it. So we knew if we chose a speed, for instance, of 40 miles an hour, we know we're going to completely essentially explode the taillight. But if we do 1 mile an hour, we may not do anything to it, right? So we kind of had to pick a middle ground to again, cause damage to the taillight.
What was your conclusion with following that?
All makes sense. And that's how you test. And Lally gets up and he's going to step in it on that. We'll wait till cross, but.
And what was your conclusion with regard to whether or not it was consistent or inconsistent with the damage to the truck? The taillight was consistent or inconsistent with making contact with John O'Keefe's head at or above 15 miles an hour?
So strictly speaking to a damage perspective, the 15 mile an hour interaction between the hybrid head form and the test tail lamp produced significantly more damage than that of the subject vehicle. So that indicates that, again, the damage on the subject tail light was less than that of the test tail light.
So I think Lally just completely missed that answer. So I'm going to make sure we don't. What he's saying is he did his testing at 15 miles an hour. And at 15 miles an hour, 9-ish miles an hour less than what the Commonwealth has put before this jury to determine beyond a reasonable doubt if John O'Keefe was hit at 24 miles an hour, that when it hit their test dummy at 15 miles an hour, it did more damage than what actually happened in this case.
If we were to if I were to ask you whether or not there would be more or less damage to the taillight if you increase the speed to 24 miles an hour, what's your conclusion?
Well, you're talking about significantly more kinetic energy. So if you just think about it from, again, a kinetic energy standpoint, kinetic energy is equal to 1/2 times the mass and the velocity squared. So if you're squaring that velocity and you're going from 15 up to 24 miles per hour, you're going to get a significant amount of more energy associated with that. Probably, I could pull up my calculator, but you're probably looking at 2.5 more times energy than the 15-mile-an-hour test.
Which means 2.5.
Again, there's some numbers in there. There may be some confusing things in there, but that's about as simple as you can put it while still explaining what happened. Hold on a second. Is the poll up? I didn't know the poll was up yet. If the poll is up, let me know. I didn't know the poll was up yet. I was going to wait till cross. So if the poll is up, so yes, the poll is up. Okay. So go ahead and vote on the poll. And I'll take a look at the results in a little bit. We're going to keep listening to his testimony for now.
2.5 more times the damage to the taillight,
Certainly.
which you did not see in your review of the materials, correct?
Correct.
So what is your opinion or conclusion as to whether or not the damage to the taillight was caused by striking John O'Keefe's head?
From a damage standpoint, it was inconsistent.
I want to shift gears back to the injuries that you saw concerning Mr. O'Keefe's arm, his right arm. During the course of your investigation, did you look at photographs and investigate the injuries to his right arm?
Yes, sir.
What's the width of the taillight, specifically from where it meets the lift gate to the left side? I'm sorry, to the side of the vehicle, the right side of the vehicle.
To the right. So yeah, as I mentioned earlier, that is about 6.5 inches. It starts to wrap around to the right side. So really, it's even though the taillight continues, it's not projecting out on the back end where it's again wrapping around. So in terms of the width that is facing the rear, if you will, it's about 6.5 inches.
And you noted that there was a dent and some paint chips that you identified above the lift gate, correct?
Correct.
How far away from the right side of the vehicle were those scratches and that dent?
Approximately 20 inches.
What was the significance of that distance?
Well, again, if to go back to your question about, I think if somebody was holding a drinking glass, right, and their arm was extended to cause that damage, or if it's theorized that those dents and chips were from that. Again, the thing that sticks out to me is that you have essentially the Lexus taillight.
So ask another question.
What's the significance of whether or not there was damage between the dent and the taillight? Or was that 20-inch area? Was it dented? Was it harmed in any way?
So in terms of, again, if we're talking about, again, looking at the back of the vehicle and we go to kind of where that right tail lamp just meets the liftgate, as I mentioned, there's another lamp assembly on the liftgate itself. There's also a chrome trim piece above that, and then certainly the body paneling to the liftgate itself. And I think what stood out to me is that between that dent and the fractured taillight, there was no observable damage to that area, which I would have expected had an arm been positioned there.
Can you calculate, or could you calculate, or did you calculate the amount of force that would be required to strike a person just only on the outstretched portion of his arm in order to project him a number of feet, for instance, 30 feet in one direction or another?
Okay, I just want to make sure I'm checking.
Take a distance out of it. Break it down.
I'll ask you the same question, but without the 30 feet.
Okay.
Were you able to calculate, or could you calculate the force that would be required to strike a person on his outstretched arm hard enough to spin him around and project him a number of feet?
If you're talking about only an interaction between the arm and the back of the vehicle, no, there wouldn't be any projection. Again, if you think about this, the arm weighs about, again, with Mr. O'Keefe would be about 11 pounds. So you still have, another 200 plus pounds being held down by gravity, and the force is only acting on the arm. So essentially the arm would be accelerated, but the whole body, because the center of mass is not being struck, would not be projected.
Again, completely logical. And what common sense would tell you that hitting somebody's arm would not propel their whole 200 plus pound body 30 feet. But now it's in evidence.
Is the absence of the damage that you described, between the dent and the rest of the vehicle, with the exception of the taillight, is that consistent or inconsistent with striking an outstretched arm of a human being?
Objection.
I'll allow that.
That would be inconsistent in my opinion.
Striking an outstretched arm of a human being.
Objection.
I'll allow that.
That would be inconsistent in my opinion.
Yeah, that's inconsistent with what he saw, that it hit his outstretched arm and threw him 30 feet. And again, that is the Commonwealth's theory. That's what they're stuck with. That's what they have to argue in front of this jury. They can't change course now.
They have just a moment, Your Honor.
Yes.
And what is your opinion, Doctor, as to the amount of damage that you would expect to see at 15 miles per hour or above on the taillight, if in fact that vehicle were moving in reverse and were to strike something on a human body, for instance, an elbow or an arm?
Objection.
I'll allow that.
I'm sorry, can you repeat the question?
Probably not.
Sorry.
I'm trying. Physics, that's why. from your testing, what would you expect to see in terms of the damage to the right rear taillight? If in fact, that taillight were to make contact with a part of a human body, for instance, an elbow or an arm, at 15 miles an hour or above, what would the level of damage be as compared to the damage that you actually saw?
Well, if we compare it to, again, looking at the drop test that we did with the hybrid head, which weighs about 10 pounds. So again, if we're talking about now a human arm that's comparable in that same weight, we certainly would expect to see a comparable level of force and damage. So as I mentioned, if the arm is outstretched across the right tail lamp and into the liftgate section, I would certainly expect to see deformation to that body paneling, even potentially the tail light on the liftgate itself and that chrome piece as well.
Based on
Even if it did happen the way they said, it still would have more damage in different spots.
the entirety of your investigation, your entire team's investigation, all the testing that you did, all the biomechanical testing and the engineering and the physics testing that you did, in your expert opinion, was that taillight damaged by striking John O'Keefe from the head?
Objection.
Sustained.
In your opinion, was the taillight damaged by either striking Mr. O'Keefe from the head or the arm?
Objection.
Sustained.
Any reproach?
Yes.
You are muted. Muted.
May I, Your Honor?
Yes.
Last question, Doctor. In your expert opinion, based on all your testing, is the damage to the taillight that you saw consistent with striking a human head?
No.
In your expert opinion, is the damage to the taillight consistent with striking a human arm?
No.
Thank you. That's all I have.
All right, jury.
So the damage to the taillight was not consistent with hitting his head or his arm. We know the Commonwealth's theory is not the head. Fine. But just in case the defense is covering all their bases, just in case a juror sitting back there like, well, maybe it just hit him in the head and that's the head injury. No. This guy crossed off the taillight didn't hit him in the head and it didn't hit him in the arm, which is the Commonwealth's theory. Ginny, so now the poll is up. Over 5,000 votes, 96% are saying not guilty on the second-degree charge. So hold, Kelsey. Don't post the next one yet. We're going to post the next one when we get to the next witness. But first, we've got to do cross of this witness. I'm going to answer some questions. Why was her decision not to testify put on the record, or did I miss it? I didn't see it either. I don't know if they did it off camera at some point. My guess they did. My guess is they did. Usually you have to do that. Best guess on when we get a verdict, I think late Wednesday. My guess would be Wednesday. Early or late, I think would depend on when we get closing arguments and everything done. So we'll see. Pib, if guilty, are we looking at manslaughter? So that's going to be our next poll during the next witness is you voted the vast majority not guilty on second degree, but we're going to do that vote again on manslaughter, which would be an accidental killing. And we'll see if that changes anybody's mind. Tinny, is anyone paying them to testify this trial? That's a good question. I don't know if they're doing it, not charging, or if the FBI is paying it because it's part of the work that the FBI hired them for. I'm not sure. BG, who did more damage, Paul or Proctor? So definitely Proctor and just like looming over the entire case. But I was really trying to stay fair and impartial. And I got to be honest, trying to think, is it possible Proctor, even though he's a douche and everything he said was horrible and despicable, and it's hard for me to believe anything he said, if Paul would have been amazing and connected all the dots plausibly and scientifically, I think he could have really helped their case. And instead he did the opposite. He provided reasonable doubt. So if there was anybody that was impartial and that could get past the despicable comments and actions of Mike Proctor, Paul destroyed it. Thoughts on Jackson doing close versus Yannetti? I think it's going to be angrier. I think it's going to be louder. I think it's going to have a lot of heat. I don't think it's going to be very nice. Cynthia, what happens at the sidebar? Do they ask the judge what they can ask? Why does she sound so annoyed? She meaning the judge. Sometimes they argue things multiple times and judges get annoyed, and I get that. What happens at sidebar is there's an objection. They say what the objection is. They argue back and forth, and the judge makes the decision, but rightfully so. And I like that the judge has done that part. I don't like the zero explanation for objections, but I hate speaking objections in front of the jury because slimy lawyers can slide stuff in, take shots during objections, and it's totally inappropriate. We saw a lot of it during the which one was it? The Hannah Gutierrez retrial, I think. Are internal affairs mixed up in this? I'm not sure. I know the FBI is. I'm not sure about internal affairs. Joanne, sorry for the stupid question. But if they find her not guilty, and they should, can she sue for the stress and anxiety this has caused? Because people may see her as guilty no matter what. There are going to be civil causes of action that she's going to have at the end of the case. We'll hold and maybe look at that after the case is over. Do you think it is a problem that ARCA didn't have the same glass? That'll be up to a jury. My answer is no, because I don't think the defense is saying that he actually threw the glass at the taillight. So I would say I don't think that's a big issue for me. I'll just say it like that. Do you think someone else gets charged if not guilty verdict? I think the answer is no. Somebody else asked a similar question. Dennis, can the two families and Higgins be charged? They could be. I just don't think that's going to happen. Do you think the prosecution shared these reports with the O'Keefes before, or do you think this is the first time they're hearing the evidence? Impossible for me to know, but that's a really good question. Aaron, or ERN, Peter, please do a live after this where you do a closing statement from the perspective of the prosecution and one from the defense based on the actual testimony. That would be cool. I don't think I'm going to have enough time for that on this case, unfortunately, but that would be cool. Tim Cheeseborough, can you think of a reason why the Commonwealth was so unprepared for this trial? It's still shocking. The ME disagreed with the accident conclusion. I don't know if disagreed is the right word. They asked for more time. I don't really think it was going to get much better for them, if I'm being honest. Azam, Peter, how long do you think deliberations will take? I want to see when closing arguments end before I answer this question. My guess right now would be by the end of the day, Wednesday, but I'm gonna wait a second. Okay, so now we get to our first cross-examination of a witness by Lally today. He starts with his report and says it was limited to the information they had, and they may change it if they need to. That was a big point for Lally to start. And then he steps in it almost immediately.
Is no longer present.
Scene's been cleared, items have been removed as far as evidence or other things. That's mostly what you deal with, correct?
Sure.
And as far as the hat that we were talking about before, is you aware that that was recovered as well? Same day as the drinking straw on February 3rd in the area where the body of Mr. O'Keefe was discovered?
In the area of the front yard, yes.
So one of the things Lally coupled with, and this was in both experts, actually, all the experts, was, well, you said on this date, if you had more evidence, you might change your report. And look at all this evidence that's not in your report or you didn't know about. Now, he didn't ask if it would have changed their opinion, of course. He just throws some stuff out there. Some of it may be reliable. Some of it may not. And because of how the evidence was gathered, some of it probably happened after their report because they were still gathering stuff like 2 seconds ago. But that's his main sticking point. And I got to be honest, if he would have just come in, said, hey, if you had more information, you might have changed your report. You didn't have this information right. Thank you, nothing else. Then maybe that point would have landed and he could have tried to discredit them a little bit in closing. It wouldn't have been perfect, but it would have been better than what he did.
Now, you have some familiarity through working as a crash reconstructionist with pedestrian collisions, correct?
Correct.
Is it common or uncommon for in the course of a pedestrian collision, for a shoe or glasses or hat or something to fall off of that pedestrian?
So Lally thinks he's got a great point. In a pedestrian accident, isn't it normal for a shoe to fly off somebody when they get hit?
In the collision sequence near where the area of impact occurs?
Well, I think that depends on the interaction between the two. If it's more of a side swipe type interaction, if we're just talking about an arm, for instance, contact the vehicle, no, I would not expect the shoe to come off. If it's something where the...
Oops. If it was a side swipe where just the arm was hit, no, I wouldn't expect the shoe to fly off. That's what you guys said happened. And you said the shoe did fly off. So no matter what way you cut it, whatever hole you poke in this guy's argument, he's saying, scientifically speaking, your explanation cannot be true. This guy crushed.
entire body is interacting with the vehicle, then yes, there's a greater likelihood that something like a shoe will come off. Yes.
So that is consistent in general terms with the pedestrian collision of the shoe coming off, correct?
Again, based on the interaction between the two. I wouldn't say it's a blanket statement that, again, in all pedestrian interactions, you will have a shoe come off.
And that's not the question I was asking. So what I'm asking is it generally consistent with pedestrian collisions that a shoe may come off during the collision sequence near the area of impact?
Shoes can't come off in a pedestrian impact, yes.
Just not the way you said it happened. He never looked at the Lexus, even though he could have. If you remember, though, Jackson and Yannetti, they knew this was going to come. That's why some of the early questions are, you guys can do this by just looking at pictures. And eventually, the experts hammer him. I thought they were really respectful with Lally, but eventually they did hammer some of his softballs when he asked them 3 or 4 times and acted like he was making a point. And they're like, no, sir, you're not making the point you think you're making.
Yes.
And essentially what you're trying to do is control as many of those variables as you can in order to best replicate whatever the conditions were at the time that what you're testing to see actually occurred. Is that correct?
Correct.
Now, what, if anything, did you do to control variables in relation to temperature?
So one of the things we did with all of the tail lamp assemblies that we tested is that we preconditioned them to approximately 28 degrees, that they'd reached a steady state temperature before we subjected them to the impact testing.
And when
Did you catch that? We're going to listen to it one more time.
is that correct?
Correct.
Now, what, if anything, did you do to control variables in relation to temperature?
So one,
Lally's planning on saying, well, this tail light could shatter because it was freezing cold temperatures and things become more brittle. That's what he wants to argue. But this guy's like, actually, we thought of that. And we changed the temperature to make it replicate that.
one of the things we did with all of the tail lamp assemblies that we tested is that we preconditioned them to approximately 28 degrees, that they'd reached a steady state temperature before we subjected them to the impact testing.
And where in your report does it say that?
I don't believe that's explicitly stated.
Is it implicitly stated anywhere in your report?
Again, it's just, I'm telling you, that's part of what we did for the testing.
I understand that's what your testimony is, but you wrote a report, correct?
But it's not in your report, sir. It's like, okay, so I didn't put it in my report. And I mean, far be it from Lally to say that if it's not in the report, it didn't happen, right? Based on all the Commonwealth witnesses. But this is just going to come down to, I mean, this guy immediately answered the question with no hesitation. So if Lally thinks that by saying it's not in his report, he wants the jury to believe that this guy is lying, right? That he didn't actually do this, but immediately without even thinking or blinking, he said, yeah, we did that. We did the control temperature. What do you think? Because I think maybe if he would have fumbled and bumbled a little bit, like we've seen some other witnesses, I'd be like, maybe he didn't do that. But that's not at all what this guy did. I fully believe that they did that with the temperature. So a bunch of people are saying Proctor's under IA investigation.
Right, and I don't know that I detailed every single part of the test. Again, we summarized it.
Understood. So what did you do to control any variable as far as wind?
Well, when you're talking about a projectile such as a glass, again, that's being projected at 37 miles per hour, again, there would be probably minimal effects in terms of the wind.
Even if there was a blizzard going on?
Again, what we're going after here is ultimately conducting a test such that the drinking glass arrived at the location of the taillight. So if you're trying to say that, okay, he threw it this way and the wind blew it towards the taillight, sure, that could be a possibility.
And so I'm not trying to say anything. I'm just asking, are you aware that there was a blizzard and that there were wind gusts up to 37 miles per hour during the time that this collision occurred, and that's not accounted for in your test?
Were you aware of that, sir?
I'm aware that
What Lally's trying to do right now, what he's taking all this time doing is trying to disprove that the glass was thrown against the light. I think that's a red herring. I don't think the defense really cares. And again, now the brittle change in the light could make a difference, but this does not.
there was inclement weather at the time, yes.
But even so, he did know that there was inclement weather at the time. So then he asked, they got into what kind of glass he used when he was testing. Lally says multiple times, you were limited by the agency who hired you on what you could do and what you could look at. Lighting wasn't bad. Karen Reed was the only one he could see him. Did you know that Karen Reed said, I hit him, I hit him, I hit him? Did you know that there was pieces of the taillight found in his clothes? He's just throwing all this stuff at him, Is it true? Is it not true? It doesn't matter. Lally's asking if this guy knew all this stuff because, again, he's trying to say you would have changed your report if you found out stuff. You didn't know about all this stuff. And then he's not asking the ultimate last question because he wants to say to the jury, he would have changed his report if he would have had all this stuff. Yes, I'm using stuff. Precisely. And sometimes that strategy can work. The prosecutor in the Chad Daybell case did something similar, and she was able to go through all the stuff her medical examiner and medical expert looked at that theirs didn't, but she also explained why it was so important and why, if you didn't look at all this stuff, her expert explained why, if you didn't look at all this stuff, you might come to the wrong conclusion. And they had a coroner that flipped her opinion once she added all of that information. So it worked perfectly in that case. We don't have that here. And no medical person with all of this additional information could give the opposing opinion. The only person that kind of did was Trooper Paul, but even he couldn't really explain why or why any of this additional stuff mattered. And of course, what does Jackson do on redirect? He comes up and he asks that final question that Lally didn't ask. And he said, did any of these questions, any of this new information you found out that may or may not be true, did that change your opinion? No. All right. So we're done with the first accident reconstructionist. I'm going to answer some questions. Hit that like button if you guys haven't already. We got 23,000 people in here. I don't know what the biggest chat is in this case so far, but this has got to be close. So let's see if we can get to 20,000 likes. If you guys all hit that like button. And Kelsey, somebody asked who Kelsey was. Let me see if I can throw that one up there. Kelsey is the newest member of the Lawyer You Know team. So say what's up to Kelsey in the chat. Kelsey, go ahead and put up the manslaughter poll, guilty or not guilty. So now everybody take a chance after you hit the like button. go ahead and vote on the manslaughter poll where you are right now. And I'm going to answer some questions. McLaughlin made me mad, arguing conscience of guilt again. Why is she trying so hard for that point? First, by hiring an attorney. Second, by driving to her parents' house in a blizzard. Yeah, what was more annoying to me is the judge was like, I'm not going to allow that. And then she goes, actually, you made a really good argument, so now I'm going to take it under consideration. I hope she does not give that instruction, especially because it's clear the Commonwealth has tried to get into that in shady ways. If they want to argue she wouldn't have driven to her parents' house unless she knew she did it, they can do that. That's an inference made based on the evidence. But to have a judge give an instruction is not great. BLT, Peter, I owe you tuition for all you've taught me about the law. Did you come up with the 13th juror doing the closing argument strategy? Brilliant. It was my dad's idea. Most of the things in the law, I'll just tell you, are not original ideas, but used from other people's successes, and we build on them. Monica, you're probably one of the Alberts scared now that it's proven the world how disgusting your family is. Shame on you. Okay, didn't read that before. Sorry. Azam, Peter, could you share your ideas for closing arguments for both sides and your opinion on Jackson Yannetti style? Reached 389K subs during this live. I mean, we've gone over a million things the defense can do. I really think the prosecution just has to say, listen, we called, 100 witnesses, however many witnesses they called over 27 days. If you really believe that all 100 witnesses are in on this conspiracy, I know that doesn't have to be true. Okay. I know that doesn't have to be true, but I'm saying if I'm the prosecutor, if you really want to believe that 100 witnesses over 27 days all came up here and just lied to you to protect Colin Halbert, fine. But what's more likely? What's more plausible? Karen Reed got mad at her boyfriend, hit him with her car, and left him there in the cold to die. They have to tell a simple story, in my opinion. They have to lean heavily on motive, angry texts and voicemails and Aruba and whatever. It's not a great argument, but that's really all they have, in my opinion. If they really get into the weeds, they're going to lose this jury. They're going to completely lose this jury because I think the defense is going to come fast and furious in their closing argument. Nick West, does this follow Lally? Probably. Can he get hired elsewhere if he leaves? Would you resent the DA's office if they forced you to prosecute this? I mean, I would have probably quit over this, if I'm being honest. If they forced me to prosecute this case, I probably would have quit. Justice for Matthew North. Trying to find your video with your dad analyzing the phone call between Yannetti and the DA. Don't see it. Was it taken down? Not in Karen replays. So the only video I can remember doing is one with like the FBI letters back and forth. If that's what you're talking about, I think it's on the Karen Reed playlist. We can take a look at that and see if it's on there. Why no bites under the arm? Top teeth only bite. So I think Russell showed where the bottom teeth would have bit on the elbow. Whoever believes Karen Reed is guilty, please explain how the evidence could be interpreted so to show John O'Keefe was struck by the car, injuries, final resting place, strange Sally Port behavior. Karen Reed is innocent. Who is Din? I have no idea. If this was my brother and I found out the FBI was investigating, I'd be re-questioning everything about the McCabe's and Alberts ever told me. What about you? Same. I agree. And that's tough. All right. So now let's jump to the next witness, Dr. Rentschler, accident reconstructionist. They go through his experience, education. He defines some terms for him, shows how smart he is. Does the same thing about, did the defense hire you? Is the defense paying you? And let's get to the bulk of his testimony here and his opinion.
Also to look at the overall evidence of where everything was found, where Mr. O'Keefe was found, what the injuries were, how they may or may not have occurred based on the damage we have to the vehicle.
So did you look specifically to find whether or not you could determine the forces required for Mr. O'Keefe to suffer the injuries that you saw in the records, medical records, et cetera?
I did, yes. I determined in my analysis whether there was sufficient force with that damaged taillight and interaction with that taillight to produce any of the injuries that were listed or diagnosed in the autopsy report in the medical records.
Generally speaking, what injuries would you expect to see in a vehicle-pedestrian interaction at, say, 24 miles per hour?
Objection.
I'll allow that. Just generally, Dr. Wood, please.
Yes, Your Honor. So 24 miles an hour, once you get up to that speed, you start to see fractures. You see significant ligament and tendon damage. I mean, usually about 15 mile an hour impact is where you start to see damage to, for instance, the leg and the knee. At that speed, you're going to produce, if you impact a vehicle, you're going to produce upwards of 1,000 pounds of force on the body, depending on what part.
Also, like, the head's not the only thing that would get injured from hitting the ground, right? If you're really thrown 30 feet, that could cause broken bones. That could cause ligament injuries. And that is remarkable and incredibly difficult for me to get over to even try to wrap my mind around how a reasonable juror could vote guilty in this case. This guy's evidence to me was potentially, just built off of each other today. One was better than the next.
Part of your body impacts the vehicle. So certainly at 25 miles an hour, you start to see significant injuries occur.
Is that true for any part of the body that is struck, whether it's center mass or extremity, 1,000 pounds of force because of the speed of the vehicle?
Well, force is equal. Newton's second law of force is equal to mass times acceleration. So the acceleration is going to be the same. It depends on the mass of whatever body part's being hit. So from the testing that we did at 15 miles an hour, we used a head form, which weighs about 11 pounds. And that produced almost 1,000 pounds of force, a little under that for the head. So anything that weighs 11 pounds is going to produce almost 1,000 pounds of force. The heavier the object, if you get hit center mass, that's going to be even greater force because that's more mass than just 11 pounds. So the acceleration is the same for each body part. It just depends on the weight of the body part and how heavy it is to determine the force that's actually exerted on the body.
Did you review, in furtherance of your conclusions and opinions, did you review records that indicated injuries to both a head as well as an arm, right extremity, right arm?
I did, yes, sir.
Taking those one at a time, is the injury to the head that you saw consistent with having been struck by a vehicle at 24 miles per hour?
It is not, no, sir.
Can you explain why that is?
There's a couple of reasons. First of all, and the main reason is that to get the injury, it was a fracture at the occipital region of the head, which is basically on the back bottom part of the head. So in order to have that part of the head contacted by the taillight, you would somehow have to have a configuration or be standing in a manner that the rest of your body doesn't get hit because there's no other significant injuries to the body. If there's enough force to cause a skull fracture, then there's going to be certainly enough force to
Right, like bending down to tie his shoe and his head sticking out and boom. You probably couldn't hear anything I just said. I just realized I was away from the mic. But sitting like that, head back, and boom, the car hits here. But again, it would be really hard to throw him 30 feet if that happened. And he'd probably have a broken neck.
cause injury to the rest of the body. So first of all, you have to determine how could you configure somebody could actually be standing to have only the head impacted, the back of the head. And even if that was the case, if somebody positioned themselves in such a manner to have that occur, you're still going to see other injuries related to that. For instance, with the cervical spine, over 1,000 pounds of force acting on the head, you're going to get significant cervical injuries, fractures, disc injuries, tendon and ligament injuries. So the fact that we only have that head injury and only damage to the occipital portion of the skull is inconsistent in this case with being struck by that tail light. And then there's also the evidence that we saw when we did the testing at 15 miles an hour where we dropped the head form. So that would be akin or like a vehicle backing up at 15 miles an hour hitting the head. We had more damage to the tail light in that test than what we saw with the subject tail light cover. So if you're going 24 or 25 miles an hour, even faster, you're going to see even greater damage, greater fracturing of that rear tail light. And we just don't have that in this case. So both the physical evidence as well as looking at the biomechanical aspects of it are inconsistent with that head injury occurring due to impact with the rear of the Lexus.
Shifting to
The science says it couldn't have happened from a car hitting the head. Okay, that's number one.
the arm, are the same forces at play if instead of the head
Just in case you didn't hear it, because I paused it, he said now shifting focus to the arm.
making contact.
Ruled out, all three experts today ruled out head. 2 out of 3 have ruled out arm getting hit by the car. Let's see if it's 3 for 3.
So like it's an outstretched arm, for instance, at the elbow area of a human being. The person 73 inches tall, weighing 215 pounds.
Objection.
The objection sustained. Ask me differently.
Sure. Shifting to the arm, are the same forces at play if instead of making contact with the head, you make contact with an arm, an outstretched arm?
They are. I just explained the force is mass times acceleration. So if the arm weighs the same as the head, you're still going to get that same force, almost 1,000 pounds.
Does the arm weigh the same as the head?
It does actually, almost identical because your arm, one of your arms, including the hand, forearm, and upper arm, is about
It's crazy, right? I never knew that your arm weighs as much as your head.
5% of your total body weight. So for someone who weighs 216 pounds, that comes out to about 10.8 pounds. So your arm, basically your whole arm is about the same, weighs the same as your head.
So is your analysis the same then if the arm, close to an 11-pound arm, made contact with the taillight traveling 24 miles an hour, at 15 miles an hour, would you expect even more damage to the taillight at a higher speed?
Objection.
I'll allow it. Watch the leading one.
Sure.
Yes, you would. If it's higher than 15 miles an hour and you have an arm actually striking that taillight, you're going to get even more significant fracturing, more damage to that taillight at a higher speed than what we saw.
So was the taillight damage consistent or inconsistent with striking an arm?
It was, our findings was it's inconsistent for a number of reasons, but it's inconsistent with striking the arm. Yes, sir.
Okay. I want to shift back to the head injury that you saw. Was the head injury that you saw consistent with falling backward from a standing position onto a rigid surface?
That's certainly one of the possible scenarios. That would create the injury mechanism. You fall backwards, strike your head on concrete. That can produce thousands of pounds of force on the head. And so that's certainly a scenario where you could produce that damage. If someone was standing, they fell backwards and struck their head on the roadway or on the curb or a hard surface.
So
On the roadway, on the curb, on a hard surface, right? And Lally's going to get into the frozen ground. But I mean, these guys are testifying like they're defense experts. Like they want the world to know this was not from a car accident. Over 5,000 votes were about 95% not guilty, 5% guilty on the manslaughter by DUI. So Maria, it's going to be manslaughter by DUI as the other charge that we're voting on here that they could convict on if they wanted to.
Ask if you may just answer my question. Those kinds of force multipliers require a hard or rigid surface or not?
They do, yes, sir.
So grass and dirt would not produce the same sort of force.
Grass and dirt, no, that would not certainly not produce the same amount of force as hitting your head on concrete.
And if it was grass and dirt with a little bit of snow on the top of it, what effect is that?
That's going to dampen and lessen the force even more so.
What injuries? I want to shift back to the
Instead
arm.
of frozen ground, they're actually saying that would make it even cushionier, more cushiony if there was snow. It's like, I don't know if I believe that, but I also don't believe that it was immediately the ground was frozen. Maybe it was harder, but all of this, guess what? All of this is something the Commonwealth should have to deal with. It's not up to the defense to prove this case beyond a reasonable doubt.
Arm, I know I'm going back and forth, bear with me. Talking about the arm, if presuming a strike at, say, 24 miles an hour on just the arm, what kind of damage would you expect to see on the arm, irrespective of the vehicle?
You can see significant damage on the arm, especially if it hits at that taillight. Enough force to actually cause fracture of that taillight, that force is going to be concentrated at an initial point. And you're going to see at that point, you're going to see probably the most damage to the arm and to the skin there. So remember, at 15 miles an hour, that's about almost 1,000 pounds. So 24, 25, it's even greater. So that amount of force on the arm, certainly you're going to see extensive subcutaneous lacerations, bruising, contusions. You're going to see most likely fracture of the arm as well. You're going to see significant damage. Just imagine having your arm out and being struck by a car at 25 miles an hour. There's going to be significant damage.
He's like, members of the jury, just imagine having your arm out and having it struck by a car at 25 miles an hour. It's like, they don't have to imagine it. That's exactly what the Commonwealth says happened in this case. And he's like, that's impossible. That can't be how it happened. And I find myself at this point, honestly, if I'm going to believe the Commonwealth hasn't proved the case, period. Okay, that's where I'm at. But I'm trying to take it a step further and see how far I really think the truth goes. And if I'm going to try to figure out and force a way that John O'Keefe was hit by a car, I'm going to have to make up a different way than the Commonwealth is pointing the finger, because everybody, even Trooper Paul, could not explain how that made any sense.
More so compared to simply the abrasions that were diagnosed and documented on the arm in this case.
You did look at multiple photographs of the arm in this case, of the John O'Keefe's arm in this case, right?
I did, yes, sir.
All right. Were the injuries that you saw on John O'Keefe's right arm consistent with having been struck by a vehicle in the manner that you just described?
Objection.
That's sustained, Mr. Jackson.
And again, that's because they're specifically asking about John O'Keefe's arm, not if it would be consistent with somebody's arm getting hit.
You reviewed injuries specific to John O'Keefe, correct?
I did, yes.
Taking that as a hypothetical, would the injuries that you saw, generally speaking, hypothetically be consistent or inconsistent with having been struck by a car at 24 miles an hour?
Objection.
Sustained.
A reproach?
Yes.
If you were
You are unmuted.
Yes.
If you were to presume, for purposes of my question, that an arm was struck by a vehicle taillight traveling at 24 miles an hour or thereabouts, would you expect to see patterned abrasions with no bruising?
Objection.
Or just, what would you expect to see?
What would you expect to see?
So again, I would expect to see significant
By the way,
trauma.
that's the judge helping out the defense. Just pointing it out. We got to point it out and call it both sides. She's telling him how to ask it to where it would be admissible, and she would allow it.
To the skin, to the bone, to the tendons. I wouldn't expect to see just abrasions, pattern abrasions. I mean, abrasion by very definition means that it's trauma to the skin, which is created through rubbing or grinding or friction. So it's basically something rubbing against the skin that basically wears away that top layer of skin. It's not blunt force trauma. If you have blunt force trauma that produces a contusion or a bruising, it's not a laceration type injury where you have a cutting injury that actually produces a cut or a significant laceration. It's really just rubbing along the skin. So that would be inconsistent. If you have an arm that's actually struck at 25 miles an hour, you're going to have significantly greater damage, especially if there's a taillight that shatters. So you have the taillight coming in, it's hitting the arm and it's moving forward into the arm. So if that actually caused fracturing of the taillight, then parts of that taillight are going to be pushed into the arm and likely embedded into the arm as the vehicle continues forward and pushes the arm out of the way. I didn't see any of that, basically just superficial abrasions, which all appear to have a similar amount of force. There's not a difference. That's the other thing. If you had a taillight shatter and explode on an arm, you would have some areas where you would have very deep contusions or lacerations, others lighter areas. But when you look at...
It's a good point.
the abrasions that were noted in this case, they all appear to be the same force, generally the same direction, and the same severity, which would be inconsistent, in my opinion, with being struck at 25 miles an hour.
Generally speaking, do you look for consistency in size of an object striking a body and the injury that the body suffers from being struck by the object?
Absolutely. I mean, size is a big part of it, certainly. Yes.
You're doing measurements of the size of the tail, the width of the tail that was shattered.
Yes.
And what was that width?
So every measurement he asks these guys about, that again, he did not prep and he did not ask them to measure any of this. Don't forget that. Because those of you that have watched a lot of trials, you're probably thinking, yeah, of course, he knows the answers to all these questions. They're going through a script. It's his expert. He told them what to measure. He told them what they needed. That didn't happen here. So every time he asked Trooper Paul, it's like, I didn't do that measurement. I didn't do that equation. I couldn't because it would probably be wrong if I did. The answer from these guys is yes, and they explain why that measurement's important and what it means and how it affects their testimony and opinion in the case.
I think the width we looked at was maybe 6 inches or so.
In review of your, in coming to your opinions and conclusions, did you look at the arm of John O'Keefe just sort of laid out, straight out?
I did, yes, sir.
Did you see where the injury started and stopped, or began and ended, however you want to put it, in terms of size?
Yes, I mean, it started from the upper arm and then extended down into the forearm, which was greater than 12 inches of length, where you see those injuries and those abrasions occur.
Did you come to any conclusions or opinions concerning the size differential between the tail light and the injuries that you see?
Objection.
Sustained.
Generally speaking, would you expect if there was an injuring event that the size of the injury would be consistent with the thing that produced the injury?
Yes, generally speaking, you would certainly expect that. And again, you would normally and usually be able to.
That was a bit of a confusing question by Jackson. What he's asking is, if the taillight's this big, would you expect the injuries on John O'Keefe's arm to span this much space? Where am I going? Here. This much space. It's like, no, if the object's this big, I would expect the injuries to span this much space, right? It's like very simple, common sense things that Jackson's getting at with this witness.
To see an initial point of contact, because that's where the most force is going to occur, where it causes that tail light to break. So you would have an area of severe damage, and then it would extend out likely to the edges of where it would contact the rest of the tail light.
From a biomechanics and or a physics standpoint, engineering standpoint, is it reasonable if someone is standing with their arm extended to be hit by a moving vehicle, let's say 25 miles an hour, and the center mass of the body to be projected?
Objection.
Ask it differently.
Is it consistent in your view with engineering principles and physics principles that you know, if an arm is hit, extended, not body, just the arm is struck, the body then to be projected?
Objection.
I'll allow that.
It's not, no. So if we have contact, your arm's down, we have contact to the arm. I mean, first of all, it's just a ball and socket joint. So the arm can move independently of the rest of the body. So with enough force, even if you're contracting your arm and trying to hold it out as tight as possible, it's going to overcome that muscular contraction and basically just move the arm. But secondly, it all depends on your center of mass. The center of mass is kind of the equilibrium point of your.
You know, I love sports, and he gives a great sports analogy. I don't know what the jury makeup is, but if anybody played football, they're going to be like, I totally get what you mean here when he talks about this, because it's exactly what they tell football players.
Body of where your weight's distributed. And for most normal people, the center of mass occurs at your umbilicus or your belly button. So wherever your belly button goes, that's where your body's going to move. They teach this to football players, right? If you're a defensive back and a running back comes around the corner and it's you against him, they tell them or they teach them to watch the waist and watch the belly button. It doesn't matter what your head or your arms do or what their feet do. Wherever their belly button goes, that's where they're going to go. So that's what you want to tackle. So even if you had your arm straight out, again, we said it would move because of the joint. But let's assume you had a metal pole sticking out of your arm, out of your body instead of your arm, and that metal pole gets hit. What's going to happen to your body? It's just going to spin around, right? Because it's producing a moment arm, which produces a torque on the body. So your body's going to basically spin. In order to get that body, or the complete body, over, for instance, 10, 20, 30 feet into the yard, you need a force acting at the center of mass. You need an external force pushing the body that way. And that's not going to happen if you just hit the arm. It's not enough force. It's not the right mechanism to actually cause the body to somehow move that far over.
Assuming that a body was struck with enough force at center mass to project that body 20, 30 feet, what injuries would you expect to be produced on that body?
Objection.
Sustained.
If you did have a body that was projected a distance, what injuries from a car, what injuries would you expect to see on the body?
Objection.
I'm going to see you at sidebar the last time on this.
It is the same thing coming up again about specific to John O'Keefe versus general.
May I interrupt?
Yes.
Doctor, do you have my question in mind? You need me to repeat it?
Maybe repeat it, yeah.
Easy for you to say. Assuming that a body was struck at center mass with enough force from a vehicle traveling at whatever speed to project the body off the ground, would you expect to find injuries on that body?
You would, and you would actually see that there's specific injuries because let's say you're standing forward and you get hit on the right side with a vehicle. you're going to get injuries and damage to the right side of the vehicle as that vehicle impacts you. It depends on the profile of the vehicle, where how high the hood comes up, whether you're going to wrap up onto the hood, or if it's a van or the back of an SUV, it will project or push your entire body to the left. So you're going to get initial contact and injuries to the right side of your body. And then if it propels you into the air, you're going to get airborne, and then you're going to contact the ground, usually with the left side of your body. So then we're going to see a correlation of injuries to the left side of your body as it slams down onto the ground as well. And at those speeds, normally you would also see more abrasions, greater abrasions or road rash along the entire part of the body, as your body then would slide until it came to the point of rest.
And you did not see that instance.
Objection.
Thank you.
They have a moment?
Yes. Mr. Lally?
All right. We are about to get to the worst cross of the trial. Unfortunately for Lally, he saved the worst for last. And I'm just going to paint this picture for you. This is the last thing the jury hears before they're going to hear closing arguments. There was no redirect. This was it. This cross was it before we get there. Nina, Peter, regarding the defense, your opinion, if they don't have the FBI experts and no Dr. Russell, were they lucky? They had enough time to find experts, especially regarding dog bites. Why so late? I don't know about the dog bites. I think they probably would have hired accident reconstructionists. They're definitely lucky. I don't know if lucky is the right word. They're lucky. They're fortunate that the FBI thought there may be an issue here and took it seriously and looked into it. That's what I will say. It definitely helped their case. Just me. During jury instruction, something came up about Karen Reed guilty because she dropped John O'Keefe off knowing it was dangerous thoughts. I would be shocked if the jury came back with something like this. Will we see these two testify again in the Fed's case? If there is one, I would assume yes. T. Shaw, is the report evidence or just their testimony? Just their testimony. The report does not go back into evidence. Jessica, I also do insurance defense. Well, welcome, Jessica. It is not lost on me that J.O. deserves justice. That said, what is your opinion on the moves post-trial if K.O. is acquitted? I expect the Commonwealth to say the defense attorneys had smoke and mirrors. There was pressure from the outside world. There was witness intimidation. It's so horrible. We still believe what happened, and there's no justice for John O'Keefe. And I expect the defense to say they proved that she was innocent. That's what I would expect to happen. And then I would expect civil lawsuits to come. ERN, okay, maybe you could just end this with your opening lines of closing arguments. We would love to see how the lawyer we know would grab the jury's attention. So one of the things about being a lawyer is preparation. It takes a lot of time to come up with good themes and good attention-grabbing openings. I think the defense is going to open similar to their opening statement, which is Karen Reed is innocent. She didn't do this. She was framed. There was a cover-up. I expect it to be like that. And I really think that Lally's best argument is, and I know somebody commented, and I'll throw it up here if I see it, is that really everybody was in on it. I know somebody said, the outsider said, the cover-up only needs a couple people from the inside. Proctor only talked to them. They pointed at Karen, tunnel vision, bad investigation. I get it. But I'm saying for the Commonwealth to act like, come on, this cover-up's not real. You make it seem like an even bigger cover-up and bigger problem and harder to be the truth. Tonks, could neutral expert be replicated in a normal case? Example, have a third party hire them, similar setup to a double-blind study, except wouldn't know who paid. Unusual or unlikely to happen in any case. And honestly, it's kind of sad. We kind of already know what experts are going to say in most cases. Elizabeth, I was more angry at the Commonwealth after these expert witnesses than I was after Proctor testified. I agree. Like, Proctor made his own mess, but after these witnesses, you think, why did you bring this case? Like, you have these unbiased FBI investigations to say he wasn't hit by a car, and you still brought this case? It's terrible. P.S. My husband graduated from FSU Law in 2009. That's right. I was an undergrad in 2009, but I was in Tallahassee at FSU. Hey, Peter, look, we're getting lawyers back to back. Another Florida lawyer here. I love listening. I tend to agree with you 99% of the time, but not 100. No lawyers agree 100% of the time. I love that you're educating so many people. Good stuff. Thank you so much, Miss Esquire. Lawyer, you know, is it normal for police officers, troopers to be the experts in the case? It seems as if there's a huge case of confirmation bias. It is pretty normal, actually, in criminal cases. Sometimes they have some experts, just like they did in this case, to celebrate people, but cops usually testify to a lot of this stuff as well. Little Fright. Last line of cross couldn't be better for Karen Reed. We're about to get there. John said, is it Chelsea or Kelsey? We got to know whom we're encouraging and laughing with. It is Kelsey. Dragon Breath. At times during Lally's cross, I was thinking if he wants to make sure he doesn't go to prison for this weak case. Maria, can the Commonwealth throw this case because they weren't ready for it from the start? No, they can't retry it later. That would be double jeopardy. So are all three experts the defense called from the FBI? No, just the last two. Also, first super chat I ever bought, you lucky guy. Well, thank you, Bander196. Just the last two. Cynthia, how do both the defense and the prosecution receive the information from an independent investigation? Also, why did the FBI get involved? So it's the FBI. They do a request for these records. Everybody gets these records that they request. It's not like they just did this for the defense. So the FBI had this information as well. If the jury finds no proof of car accident, can they draw any other conclusion other than a cover-up regarding taillight on the scene? Thank you, Peter. They could, I mean, they have another potential option that John O'Keefe threw the glass at the taillight, I guess. I don't think they're going to have to make that decision necessarily. If they find no car accident, they go to not guilty and it's over. Why no new investigation into who/what killed John O'Keefe if KR is found not guilty? Araya, it usually never happens because there's so much reasonable doubt, because whoever else you would charge would just point the finger at Karen Reed, and all these witnesses already testified that they thought it was Karen Reed, so it becomes very difficult. Jim, did the Commonwealth have an off-ramp given their dearth of evidence besides not proceeding? Could they have shortened the witness pool and made it a shorter trial, like 2 weeks? They could have, but knowing this stuff is coming is so bad. They should have gone to Karen Reed and been like, please don't sue us. We're going to drop these charges. ERN said email 613 regarding personal injury. If you ever have a minute, please check. We will look on that, John. Take a look at that, please. John O'Rourke, where these witnesses/experts hired originally for the Commonwealth and the Commonwealth chose not to call them? No. This was in the third-party investigation by the FBI. Or is that incorrect? Random thought. KR didn't pay for these experts. Correct. She did not pay for these last two. These are FBI experts investigating the investigation. Why couldn't Attorney Little ask questions that reference arm position that TR Trooper Paul asked? So she did. Multiple sidebars and a break. She did ask that. She just couldn't specifically ask if John O'Keefe's arm was like this and the car did this. She could say, would it be consistent with somebody holding their arm like this? So she did ask those questions, but it was more in a hypothetical than specifically about John. Chiricity, did you see the video of BH leaving the bar at the end of the night? He's talking to John, shakes his fist. BA was there. John gets up and reacts. BH sends a text at 12:20 to John saying, you coming? I don't know. I think if there was more to it, the defense probably would have used it in their argument. And I did see, I was tagged in that on Twitter a little bit. I didn't look into it a ton. Okay, so let's get to this cross-examination. There was a sidebar. And let's take a listen here.
Yes, sir.
And you're familiar with pattern abrasions?
I am, yes.
And pattern abrasions are injuries that show a distinct pattern that may reflect the shape of the impacting blunt objects that you may see with reference to injuries that are left by that blunt object. Is that correct?
That's correct, yes, sir.
Now, as far as in general terms, from what you reviewed, at any point in time did you look at a state police reconstruction report?
I don't believe that I did, no, sir.
You weren't provided with that, is that correct?
That's correct, I don't believe so.
You weren't provided with any sort of forensic reports, DNA or anything like that? Is
Imagine if he was. Imagine if he could have picked apart Trooper Paul's reconstruction report.
that correct?
I don't believe so, no, sir.
And this is, again, along the lines of Lally saying, you said you would have updated your report. Here's all the stuff you didn't have.
And you never actually looked at the physical car, is that correct?
I did not, that's correct.
And you're aware that the physical car, being the defendant's car, is still in law
So remember that. That's the first time he asked this witness, you didn't look at the physical car. And the guy's like, I did not. A polite answer. Wait till the second time he asks.
enforcement custody and available for inspection if you would want it to. Are you aware of that?
I think I'm aware of that, yes, sir.
You never made that request, is that correct?
That was not necessary in this case to inspect the vehicle.
It was necessary.
The second time he asked, he's like, sir, it just wasn't necessary. It's still respectful. I didn't mean to infer he wasn't respectful, but he explained his answer. He's like, I didn't look at it because I didn't need to. It was not necessary. And then listen to Lally's follow-up question to that.
You never made that request, is that correct?
That was not necessary in this case to inspect the vehicle.
It was necessary. No, you didn't make that request, correct?
Yeah, I don't remember if we made that request or not. We obviously didn't look at the vehicle, but it wasn't necessary in this case.
Did you ever look at the actual taillight pieces or the taillight housing? Is that correct?
Whether it was necessary or not, you still didn't do it, right? It's like, no, sir, I did not do anything that was unnecessary. And it seems like Lally may do some things that are unnecessary, as we saw throughout this case. But this guy's like, no, I didn't do it because it wasn't necessary.
Not the actual, we looked at photographs of the evidence, yes.
Now, the injuries that you observed or reviewed in materials in regard to Mr. O'Keefe were primarily on the right side of his body. Is that correct?
Well, sir, on the right arm, in the posterior aspect of the right arm, yes. And then the skull fracture was a little bit to the right, the occipital fracture.
Also bruising on his right hand. Is that correct?
There was bruising on the back of his right hand,
On the
yes.
dorsal aspect.
Yes, correct.
And there was also bruising on sort of the posterior of his right knee. Is that correct?
There was a small bruise, I believe, yes, sir.
That's the bruise Little put up on the redirect of the medical examiner, and it was very small.
Now, with respect to within your report, you talk about the numerous linear abrasions on the posterior of Mr. O'Keefe's right arm and forearm, correct?
Yes, sir.
And in relation to those injuries, there's a sentence in which you or whoever authored this part of the report, assuming it's you, indicate that furthermore, any such injuries would be highly improbable if Mr. O'Keefe was wearing a jacket, correct?
Yes, sir.
Are you aware that Mr. O'Keefe was not wearing a jacket other than a long sleeve sort of hooded shirt?
I believe that came to light afterwards. Again, it doesn't affect my actual opinions in this case, but it was a sentence added in there, yes, sir.
And so
That was probably the best point Lally made on cross. It wasn't that important, but that was probably the best point Lally made on cross, because now for the next 7 or 8 minutes, it's about to go downhill. Make sure you guys hit the like button if you haven't already. This has to be our biggest chat during this trial. I don't know if John is watching or not, but I feel like this is our biggest chat in the trial, which is awesome. Thank you guys for joining me. Thank you for all the comments and all the questions. It really is mentally stimulating for me to hear what you guys think about this case and to make me work and how I think and watch these lawyers, what I would do differently, what I would do the same, how I'm learning for them. It's really cool. So I appreciate you joining me for the ride here.
also within your report, same paragraph, you indicate blood and DNA transfer would also be highly probable under such circumstances, none of which were reportedly found on the tail lamp assembly or any of the fractured pieces, correct?
Correct.
Are you aware that DNA consistent with that of Mr. O'Keefe was actually found on the tail light housing from the defendant's vehicle?
I'm aware after we wrote or issued the report that it became known to us that I believe DNA was tested and some DNA was found, I believe a small amount. I don't believe any blood evidence was located or found on any pieces, but there was indication of DNA on the taillight housing.
There was also DNA matching Mr. O'Keefe that was found on the exterior of a piece of drinking glass that was found right near his body.
I believe so, yes.
And there was also pieces of approximately 1/16 of an inch by 1/16 of an inch of clear and red plastic that was subsequently found to be consistent with the defendant's taillight that was found embedded within Mr. O'Keefe's shirt.
Within the shirt, I believe, yes, sir. Not his actual body.
And so this is all things that you found out after you issued your report in February of 2024, correct?
That's correct, yes, sir.
Now, when you were talking about the injuries to the back of the head of Mr. O'Keefe, consistent with coming in contact with a hard surface, correct?
Yes, sir.
Would that hard surface include if the ground was frozen?
Well, you'd have to perform an analysis actually, because you'd have to determine how hard that ground was. You'd have to look at the freeze and thaw cycle, probably leading up to weeks of that. You can't just look at ground and say, well, it's below freezing, so that ground must be frozen. I mean, is it a possibility? It may be, but you have to go through an actual analysis and procedure to determine how hard that ground is and whether it could have produced those injuries.
So it is something that's capable of being done by you, is that correct?
Performing that type of an analysis? You could go through and do it, sure, yeah.
And you didn't do it, correct?
No, I did not do it, no, because yeah, there's no need in this case. We don't know what happened in this case. There's no indication of, certainly it's not consistent with getting hit by the car and ending up where he did, even if the ground is somehow hard enough to cause that type of an injury. Again, there's no movement and no force to get his body over there, and the damage with the car is inconsistent with him being struck by it. So whether the
I got to be honest, I think that was a better explanation than Jackson got out of him on direct. I'm going to back it up so we can listen again. Peace out, Azam. But I really think that was an even better explanation than what Jackson got out of him on direct. He just blows the whole case up right there. It doesn't matter if that was rock hard asphalt that we saw or found John O'Keefe's body, because there's no way he could have been projected there by getting hit by a car based on the damage to John O'Keefe and the damage to the car. During this cross, honestly, I've been not guilty pretty much throughout the trial. You know, once we got near the end of the Commonwealth's case and once we heard Trooper Paul, I was like, yeah, if that's your theory, you didn't prove it. You just didn't prove it. And that's basically where I've been since Trooper Paul's testimony. During this cross-examination, things changed a little bit. And I'll kind of explain it as we get a little bit more into it here.
you could go through and do it, sure, yeah.
And you didn't do it, right?
No, I did not do it. No, because there's no need in this case. We don't know what happened in this case. There's no indication of, certainly it's not consistent with getting hit by the car and ending up where he did, even if the ground is somehow hard enough to cause that type of an injury. Again, there's no movement and no force to get his body over there. And the damage with the car is inconsistent with him being struck by it. So whether the ground could cause it or not, the roadway could cause it, the curb could cause it, a back could cause it. There's numerous different possibilities. And we don't really have enough evidence in this case to determine what one specific event actually caused that injury.
You didn't
So before we get to the end of cross, let me just hit a couple of these. Lady Losandra, Peter, honestly, do you see an acquittal happening? Yes, I do. I see an acquittal happening in this case. Ashley, what's your best guess at what really happened? Yobi, with all the evidence, who do you think killed John? So it's going to annoy some people, and I get it. This is not necessarily the question that I press myself to answer. I usually press myself to answer, do I think it's guilty or not guilty, and why? And I think it's not guilty because the Commonwealth came nowhere near proving this case. But I think what the defense did in this case that I was not expecting was with these last two witnesses, I think they've proven to me beyond a reasonable doubt. I will just say that. They don't need to. They don't have a burden. It doesn't really matter as far as the case goes or what the jury has to do. But I think they've proven to me with these last two, maybe three witnesses, even over Lucky, like I could see some issues with his. I know people loved him. He seemed like a very nice guy. And like, I'd love to have, a client or a fact witness testify like him. I think he's a really likable guy. But these last three witnesses, to me, proved beyond a reasonable doubt that John O'Keefe was not hit by a car. And if he was not hit by a car, then Karen Reed could not have killed John O'Keefe. And to me, I think if the vote was, you have to vote beyond a reasonable doubt that Karen Reed did not hit John O'Keefe with her car, I think I would be able to vote yes to that. I did not expect myself to get there. I kind of thought I would be in the bucket of, I don't really know what happened. I honestly, I don't know what happened. And I still feel like I don't know what happened. But I feel like one of the possibilities I can rule out is that Karen Reed hit John O'Keefe with her car. I think I'm comfortable ruling that out. I don't know if it was a fight. I don't know if it was an accidental trip and fall. I don't know if his body was moved. I don't know any of that. I think all of those are plausible. Nobody proved beyond a reasonable doubt to me that those aren't possibilities. But I feel like Karen Reed did not hit John O'Keefe with her car. I feel like the evidence has proven that. And I got to be honest, I'm surprised. I did not expect that even up until yesterday. Yesterday, I figured at the end of this case, I was going to be a pretty strong not guilty because they just didn't prove it, and I don't know what happened. And there's more to this testimony that's going to kind of say that. And I know there's going to be people mad about that. Hopefully, I've been clear in explaining why and how I got to where I got. And it has nothing to do with text messages or voicemails or motives or cover-ups or things like that. I'm just saying, based on the scientific and medical testimony I'm confident in, and I understand dealing with experts like this and what they can and can't say and what they're careful to say and what they'll just say on a whim. The way they've testified in this case, I'm confident in what they believe and they're experts, and especially the unbiased independent ones. That's where I land. And I get people are going to be mad about it. I understand. And I understand people are passionate and they want justice for John O'Keefe. So do I. But justice comes with the truth. And I really feel pretty confident in that stance. And we still have more to talk about, and we'll see if something changes after closing arguments, of course. But we still have more of his cross-examination. In his cross-examination that we're going to learn. Liz said, "Do you now believe this is a conspiracy to frame Karen Reed?" I definitely think that the cops felt like it was Karen Reed, and they wanted to do what they could to make sure they got the person they think did it. I don't know that the McCabe's and the Alberts and everybody else was necessarily in on it, or that, he died at their hands inside the house. I don't think anybody's proven that to me. But if you ask me if that's more likely than Karen Reed hitting him with a car, based on what I just said, based on this evidence, I think any of that stuff is more likely than her hitting him with a car at this point. Phantom said, defense could not prepare ARCA witnesses. I think they could have called them and talked to them. They stated such in response to Commonwealth motion to discover. No, of course they couldn't do it now. The jury doesn't know that, though. The jury does know it. He said, we've never spoken before. That includes prep. All of these witnesses, they've heard the lawyer say, you were prepped by Lally. You met with him here. You met with him there. And they know they didn't meet with this person. Yobi, what product do you use in your hair? It's Layrite. I get it on Amazon. Something like, I don't know, maneuvering wax or cream or something like that. It's a blue canister and it's called Layrite. Esther said, can I get a birthday shout out? Happy birthday, Esther. Got myself a membership for a gift for my birthday. I appreciate your insight. Awesome. Members Only Live is going to be, I think, tomorrow or Wednesday. It's this week. Brandy, thank you for your recaps. I am so glad to see attorneys I respect reacting the same way I am on this. Makes me feel like I'm not in the Twilight Zone. Oh man, these cases can really make you feel like you're in the Twilight Zone. They really can. I've seen some people in the chat say they're watching the stream daily with you. So that's cool. That's really cool. All right, let's listen to the rest of this cross.
Have enough evidence based on what you were provided. Isn't that fair to say?
Could cause it. There's numerous different possibilities, and we don't really have enough evidence in this case to determine what one specific event actually caused that injury.
You didn't have enough evidence based on what you were provided. Isn't that fair to say?
I didn't have enough evidence based on what I was provided, and even looking at the additional evidence that I became aware of after the fact, there's still no evidence. I mean, you can't.
So he just crushed Lally's whole point of his cross. Well, you didn't have enough evidence because you didn't have everything. He's like, well, everything I had and now everything I know about that's been provided, there's still not enough evidence. He's providing reasonable doubt at this point. But at the same time, he's not just providing reasonable doubt, but he's crossing out that a motor vehicle caused the injuries like this.
Deny the science and the physics as to what would have happened if he was struck by the vehicle. So anything past that, you have to somehow overcome that hurdle, which is very difficult to do.
When was it that you looked at this additional material? Who provided it to you?
We were informed after a report was issued that DNA was found. And that was really the primary issue. I believe that some DNA was found on the housing, which again, there's numerous explanations or ways that DNA can get on a light housing.
So there's again, Lally hitting some of the same points, giving this guy, what I noticed with this guy is giving him 2 bites at the apple during cross. He crushes it the second time. Because the first time they asked about the DNA on the housing of the light, he's like, well, no blood, but yeah, that's true. That did happen. The second time he gets to talk about it, he's like, yeah, there was some DNA on the housing, but there are lots of explanations for that. Like he rubbed up against it. He touched it. It's his girlfriend's car. There's a million different ways his DNA could end up on the housing, right? And he hit it the second time around.
Let me ask you this, sir. With regard to the materials that you were provided with, was there anything in there that stated that Mr. O'Keefe's skull fracture on the back of his head was caused by contact with the tail?
No, I don't believe there was anything in those materials that stated
Is there
that.
anything in those materials that indicated or that anyone stated at any point in time that Mr. O'Keefe's arm was outstretched at the time that he was struck by the vehicle?
No, sir, there wasn't.
Was there anything in there indicating that his arm was tucked in at the time that he was struck by the vehicle?
You know, there's no indication in any of that evidence of what he may or may not have been doing, how he may or may not have been positioned. I mean, that's the whole issue. There's no evidence to indicate what may have allegedly occurred in this case.
Now, a typical pedestrian collision that you see through the course of
Again, every answer now to Lally's questions are hammering home reasonable doubt.
your work involves a pedestrian being struck by the front of a vehicle. Is that fair to say?
No, I see all types of different people getting run over backwards, cars spinning, hitting sideways, frontal impacts certainly occur, yes, but we see pedestrians getting struck by all parts of the vehicle.
I'm sure you see all kinds. What I'm asking is predominantly when you see a pedestrian collision, the typical pedestrian collision would be a pedestrian crossing a road in front of a vehicle as it's approaching. Is that correct?
That's certainly not uncommon, yes, sir.
Now, as far as maybe describe a little bit on your direct testimony, as far as there's differences in the type of injuries that you would expect or anticipate depending on how the vehicle interacted with the pedestrian in a pedestrian collision, correct?
Yes, sir.
And as far as you're familiar with what's called the sideswipe collision?
Yes, sir, I am.
And am I correct when I say that in a typical pedestrian collision with pedestrian crossing in front of a vehicle?
One of their big things, right? Sideswipe, can't prove it, et cetera, et cetera. But now he's going to give this guy a chance to talk about the sideswipe.
There are a number of different types of interactions as far as a wrap and a forward projection versus a fender vault versus a number of different ways that a pedestrian can interact with the front of a vehicle, correct?
Lally's trying to, use big words and show he knows what he's talking about here.
It depends on the position of the pedestrian and certainly the profile of that vehicle and the speed of the vehicle. Yes, sir. There's that.
So Jinx, you owe me a Coke. That's brutal and horrible. And that's what we can't lose sight of when we talk about these cases is the unknown questions are sometimes like when I have cases that people are frustrated, people won't, even if we settle the case, they won't admit that what they did was wrong. And some of those unanswered questions or unknowns haunt people, truly haunt people. It's brutally sad to see and be a part of. And that's why hopefully our justice system can provide justice. And sometimes it doesn't. And it is really sad. Okay, the defense's case in chief was 7.5 hours. That's like one day compared to 20 something.
Many different factors involved in it.
And so in a typical pedestrian collision, when a pedestrian is struck by the front of the vehicle, that involves more of an assumption of the velocity of the striking motor vehicle by the pedestrian than you would expect to see in a sideswipe collision, correct?
Well, I mean, yes, generally speaking, a sideswipe means that the person or the pedestrian in the vehicle don't obtain a similar or common velocity. So if you're standing in front of a car and
What does that mean? What does that mean, sir? Please explain to me what that means, that they don't share the common velocity.
person or the pedestrian in the vehicle don't obtain a similar or common velocity. So if you're standing in front of a car and it hits you, it's going to speed you up to that same speed and then disengage. Sideswipe means that there's not this mass-to-mass impact. By its very nature, sideswipe has minimal forces. We see it even between vehicles that just rub against each other. So if there's a sideswipe impact with a pedestrian in a vehicle, there's going to be very little damage to the pedestrian. And similarly, there's going to be very little movement. There's really no force at all acting. You know, for instance, if a car came and swiped your arm, swipe by your arm, but didn't have enough force or enough contact to cause any damage, well, it wouldn't actually cause any movement of the person either. So a sideswipe by its very nature involves minimal impact, minimal forces, minimal velocities.
Well, sir, did you know that that's precisely the Commonwealth's theory, is that John O'Keefe was sideswiped by this car? And even more unlikely that he is then projected 30 feet because there was not that transfer of velocity.
Also contained with in the reports that you at least co-authored, there's an indication that Mr. O'Keefe's injuries, at least to his skull, the fractures to his skull, are consistent with him having been pushed or possibly been impacted by the subject Lexus and fallen backwards, striking his head. Isn't that correct?
Yeah, so that's another possibility. If
Sorry, sir, yes or no?
No, let him answer. Let him answer the question.
so if we're saying that there's enough force if you fall backward,
I think this is his last answer, where he's just like, anything could happen in this case, dude. We just don't have the answers.
if
Sorry, sir, yes or no?
No, let him answer. Let him answer the question.
So if we're saying that there's enough force if you fall backwards to strike your head and cause that skull fracture, well, he could have slipped and struck his head. The car could have backed up and not known that he was there and nudged him and caused him to fall. I mean, any event that would cause him to fall backwards obviously would result in him striking his head. So there's numerous, almost infinite possibility of different scenarios that could result in that type of an event.
Thanks.
Numerous infinite possibilities. Now, Lally may have sat down because he thinks that the fact that he said, you know, Karen Reed could have bumped him with the car, he could have fallen in his head. Lally's like, haha. Even he said he could have got hit by a car. But this guy's saying, no. He was specifically explaining the head injury. But the damage to the car, the damage to the arm, all of that kind of explains this was not somebody who was projected 30 feet, which is in fact the Commonwealth's theory. And that's kind of my point, is it seemed like the Commonwealth was willing to take anything they could get as far as like maybe there was some collision between the vehicle and the person, and that's what caused this collision and this death. And that's what they were going to go on. So everybody hit that like button if you haven't already. 27,000 people is wild. Make sure you subscribe. There's like 40% of people that watch these that don't subscribe. We're trying to get to 400K here. So please subscribe to our channel if you haven't already. Somebody asked here, are we going to be covering other trials? Absolutely. We're always covering trials here. So make sure you subscribe and hit the reminder bell so you can be on track with the next one. Peter, our own expert opinion, verdict watch. Allison, there will probably be some kind of a verdict watch at some point, depending on how quick the verdict comes in. We'll see. I'm going on vacation Thursday, so we got 2 days to see if this verdict comes in. Curvaceous, Peter, any update on the writ hearing in the YSL trial? I have not seen anything. My dad's kind of tracking that one, so if something pops up, he'll let me know. Melanie R's, do you think the defense had to do conspiracy theory to prevent, if not her, then who mentality from the jury? Giving them a potential reasonable doubt as another person, I don't think is ever a bad idea, but sometimes you can go too far in creating a burden of proof. Allison, it appears that the Commonwealth did not produce a rebuttal witness to the dog bite testimony, correct? What's your opinion on that, and what, if any, impact? I think any of his cross-examination questions fell completely flat on that. I think they made no headway there. Danielle, so if the defense is saying cover up, should they say something in closing that they don't buy into, give them an out, but still not guilty, or no? They should explain that they do not have to determine that there was a cover up for them to vote not guilty. They should explain that. Ellen, will you be on for another trial we can watch? Yes, I think Alec Baldwin's probably the next one. We're following Brian Koberger and Sarah Boone. There's a bunch of cases we're following. If you go on our YouTube page and you check out the playlists, you'll see all the different cases we're following at once. Allison, how will we be? And also, if you guys say, hey, I want you to follow this case, or I'm really interested in it, and there's enough interest, then I'll jump on and take a look at it. How will we be immediately notified of the verdict, acquittal, afraid she doesn't remember a thing? Either way, let us know how to join Verdict Watch. Twitter, Lawyer, Instagram at Tragos Law. Follow me on those 2 sites if you don't already, and we'll announce that we're going live on there. Hypothetical, could Karen be charged with OUI if the Commonwealth found out she hit an object that night? Curious for double jeopardy. So she cannot be charged under the same set of facts and circumstances as she was in this trial. That is double jeopardy. Tommy, how can the Commonwealth go through all the pretrial motions and defense motions, state the FBI witness in reports 95% agrees with their case, has to be recourse? The waste of time, energy, effort, resources on this and just heartache is brutal. Kathleen, can you explain how this got brought to court? Meaning, what can you do as someone in the DA office to prevent something like this? You stand up, you say no, you say I'll quit if I have to. I stand for justice, and you let everybody know that if they go against you, and you use what you can to try to fight for justice, even when it's hard. Juana, why was Lally so rude? Am I wrong? Now, there were certain parts that he was rude. I don't think it was, horribly over the top, but people have felt that way about Lally the whole trial, and I haven't really. Some of it, yes. Mego, do you disagree, though, that if Karen Reed did not hit John O'Keefe, the cops had to have planted her taillight pieces there? Maybe that doesn't prove the Alberts or McCabe's were involved in the cover-up, but police sure are. Or he threw the cocktail glass, and then it was set up later. Or, I don't know. Yeah, I think it's probably, I don't feel as confident saying that, but I think that could be the case. Maria, I think she's been proven not guilty, but the Commonwealth had all this beforehand. And that's why I don't understand why the case was even brought. A lot of people don't understand that, including me. Judy, Peter, Lally has a job to do and a pretty crappy case for him to have to try. Do you think he believes the Commonwealth theory? I hope he does, because his job is not to convict. His job is to fight for truth and justice. So his job is not just to go out there and try a case. It's not. Kelly, will Lally face any kind of backlash from his own peers or the district court for his terrible job he did for this trial? I don't know. We'll see. Today's witnesses put the Commonwealth theory to bed, 100% not guilty. I can't understand how the Commonwealth continued with these charges after getting these reports. It's tough. What does your screen look like managing super chats? How are you not a member, Yobi? Become a member. I'll show it during the members only live. Other people probably don't really care what it looks like. Emmy, the prosecution had a copy of the ARCA report before the trial started. Why on earth would they proceed with this case? It's tough. Jojo, are defense cases usually a lot shorter than prosecution cases overall? Yes. Not usually this big of a disparity, but yes. Well, actually, sometimes they don't have a case, or they have one witness or just their client. Canton was not prepared for Alan Jackson. Welcome, jury pool. Danny B, thank you, Peter, for being our captain through this trial. You've provided an objective, open, and wonderful point of view. Justice for Officer John O'Keefe. I'm sure we'll have a drink with a cucumber when it ends. Cheers. I could use one. My voice is starting to go. 2-hour lives are not my cup of tea. Danny, imagine if these experts had video of Karen backing into John's vehicle. Full reconstruction would have been done. Yeah, but they did kind of say they didn't expect that to cause a cracking of a taillight. So I do think that could have been an issue potentially that maybe Lally didn't go in too smartly because he didn't know the answer. But I think potentially these guys would have thought that little tap wouldn't have caused a crack either. But I don't know. Thank you, Michael Tunsil, for the super chat here. Salty Beach Girl, pretty sure I understood with Emily D. Baker they had an involuntary manslaughter. I'll have to look. I did not truthfully watch all of the jury instructions be read. A bunch of new members here. Laura, CM, right in the nick of time. Miranda for our June members only live. Jay and Linda. And of course, Yobi is going to be there. John or Yobi, remind me to show you what it looks like in the members only live. Now you are, in fact, a member friend. John, what about saying if the glove doesn't fit, you must acquit? That's the famous line from OJ, correct? OJ walked guilt-free. Most people find KR not guilty, but not innocent. Does Netflix happen next? Wow. You know what? Next, you said most people find her not guilty, but not innocent. When we break down closing arguments, I'm going to ask that. Guilty, not guilty, or innocent as your 3 options, even though that's not what the jury has to decide. How much do lawyers charge at this level? Be honest. This case had to cost $1 million. This defense had to be 7 figures. Chris, SJ, Chance, and Kara, all new members. AJ and Yanetti's hourly rate tripled for future cases. Sure. Why doesn't Karen go up for the sidebar? I don't know if that's just not how they do it. Most courtrooms, the defendant does not go up for sidebar. And the last one, Mia's Dolphin. Thank you for being classy. Grew up with some Love my Canton. Let's go. All right. That's all I've got. Make sure you're subscribed and the reminder bells hit. We're out of here. Hit the like button on your way out. Till next time. Peace. Thanks for watching another episode of The Lawyer You Know. If you enjoyed the episode, please hit the thumbs up and share with your friends who may be interested here on YouTube. And don't forget to subscribe. You can also follow us on Instagram, Twitter, Facebook, and TikTok. And don't forget to check out the Lawyer You Know podcast with new seasons dropping every quarter. If you have a case you want to talk to us about, if it's a personal injury case, wrongful death, catastrophic injury, car accident, or slip and fall case, please email us at lawyeryouknow@gmail.com. And of course, all these links I just mentioned are included in the description below on this episode and every episode. So until next time, this is Peter Tragos, the Lawyer You Know.